We're here to consider three bills. We originally had Chairman Ralston's House Bill 572, I think was the number. He's had a family situation arise, so I think we're probably going to go ahead and just reschedule that for the meeting next week, if that meets his schedule, given the distance. And if not, then we'll just reschedule it for a time certain in the future, as per his request. Another bill that we have on the agenda, Representative Amy Carter's from Valdosta area, and she has House Bill 651. She asked me to handle it. I don't know if I'm going to really handle it other than just open it up for discussion and conversation. It should take just a very short time. And as you can tell from materials in the folder, it's regarding providing information in the statewide registry of sexual offenders to all schools in the state. The bill strikes language requiring the department to send the information to each school in the state, and inserts language requiring the department to provide access to the information in the registry. And it's really a cost saving. From my conversation with Representative Carter, it's simply it's a compliance. It meets the particular aspects of compliance as it relates to sex offender reporting, but it does so without requiring the information to be printed and sent. I think it will end up saving the state, according to Representative Carter, somewhere around $35,000, $50,000 a year in annual cost. So it's really more of a cost-saving measure than anything else. In an 18-point-something billion budget, that's not a tremendous amount of money, but it's more money than we had before. So that's the nature of the bill. She'll come, no doubt, in the beginning of the session next year with a substitute or this bill itself to bring it forward. Is there any discussion on that? I just wanted to make sure we got that out there on the record. Okay, seeing none. We'll start today with House Bill 582. Chairman Willard, Mrs. Harden is going to go grab Chairman Willard, and we'll begin. There are a lot of people signed up, a fair amount, not a tremendous amount. I may, just depending on how many people are ultimately going to testify on 582, ask to limit your remarks to 5 minutes, which doesn't sound like much, but it really is. To the extent that people that are signed up will be reflecting the comments of those who previously testified before them, I'd ask you just to keep that in mind. That is in no way, shape, or form asking anyone to not testify if they have strong feelings about it. We run a very open process here, but that open process can be time-consuming, and that's the trade-off. So I'd ask you just to please keep that in mind. But anyone who wants to be heard will be heard. That is that's a guarantee. So with that, Chairman Willard, as always, welcome.
Thank you, Chairman. Let me provide a little background regarding the bill, House Bill 582. This was brought during the session. It was brought at the behest of several groups who had concern dealing with the victimization of minors for prostitution, and the thought is to examine whether what we have as policy of the state with the criminalization of minors involved with prostitution should be reviewed, possibly altered as the approach that we take. This is an extremely important bill. The bill is fairly simple. It merely provides a minimum age of 18 for commission of the crimes of prostitution and masturbation for hire. You recall in Sunday's newspaper, there was a story in Atlanta newspaper. There's widespread concern in this city about the phenomenon of sexual trafficking of children and youth, and many organizations, including a broad coalition of churches and faith-based organizations, have joined forces to address this terrible problem. Atlanta was identified as one of 14 cities with the highest rate of child prostitution in the U.S. It is a problem that is not limited to just big cities. Unfortunately, it has spread to the areas across Georgia and certainly the suburbs of the metropolitan areas. There are 43 co-sponsors of the bill from both parties. There's strong support for the idea that we should be dealing with minors who have been prostituted as child victims in need of treatment, not criminals, who should be arrested and prosecuted. In fact, this year, Governor Perdue appropriated nearly $1 million in fiscal year 2010 budget to fund and expand system of care, to increase resources for regional assessment centers, and to add bed space to treat children who have been sexually exploited. There are also federal stimulus dollars for violence against women and girls that are available to address this need. Looking specifically at Georgia law, it is pretty clear that because of their age, children engaged in prostitution or masturbation for hire are child sexual abuse victims, not criminals under law. A child under the age of 16 lacks the legal capacity to consent to sex. A child under 18 employed or used for sexual gratification by an adult more than 5 years, his or her senior, is a victim of sexual abuse, and a minor is prohibited from engaging in employment which is injurious to their health and their morals. Children under 18 coerced into sex are victim of illegal human trafficking. Children under 18 are legally incapable of entering into binding contracts. The purpose of House Bill 582 is to recognize that minors lack the legal capacity to enter into sexual or commercial elements of prostitution or masturbation for hire. So these laws should be amended to reflect this by enacting a minimum age of 18 for commission of these crimes. This is an important first step to address the needs of child victims of prostitution and to receive rescue, support, and services in lieu of arrest, detention, and prosecution. This type of legislation, I understand, has also been addressed in 2 other states that are concerned about this as a policy of their own jurisdictions. And I ask that we at least weigh the factors that we're addressing in this bill to see if there is need for adjustment of our policy, Mr. Chairman. Thank you for the opportunity to address the committee.
Thank you, Mr. Chairman, for your comments. Let me admonish everyone if you could put this on off or vibrate, just some sort of quiet setting. I'd appreciate it. Let me, before we open up for questions to the author, we had a meeting yesterday, and just for members of the committee, we had. Let me just remind everyone gently that we are in the interim. It's not as if a bill's going to be shooting up to the Rules Committee anytime, in about an hour or two. And we had some elevated tone yesterday, and we had some vigorous debate, I think I'll call it, hopefully a diplomatic manner. I would just admonish members to please remember that we're in the interim. These are serious issues brought by serious people, and people have varying viewpoints, and sometimes we agree, sometimes we disagree, but we can always agree to disagree and to do so without being disagreeable. So I would just respectfully ask members to remember that as we're engaging in Q&A with the various witnesses. Thank you. With that, any questions for the author from the committee? Mr. Everson.
Thank you, Mr. Chairman. I just have a simple question. Mr. Chairman, thank you for this legislation. You referenced 2 states, or you're at liberty to tell us what those 2 states are.
One is New York, and I think the other one is Michigan. Is that where is it is Michigan, correct.
All right, thank you.
Mr. Franklin.
Chairman Willard, you had indicated that a child under 18 doesn't have the capacity to contract for prostitution. Did I get that right?
What we're dealing with there is the ability of a minor to enter into an agreement, a binding monetary agreement, and that is a contract. And yes, we're saying that from the civil law, they're not able to do what we do as adults.
So would it also be your position that a minor does not have the capacity to understand entering into a binding contract to hire someone to kill her unborn child?
I'm not going to try to go into what they may or may not understand as being.
But should she have the legal ability to do that, protected by the state?
A legal ability protected by the state. I think you have some things that address what is required of a minor as far as abortions, and they have to get their parents' approval, as I recall, under our state law. Correct?
You're the attorney.
I understand about. You calling for me to try to tell you what the state law is right now. I'm saying I believe the state law requires parental consent.
And looking at the bill, is it your intent that a 16 or 17-year-old could voluntarily prostitute herself out and maybe make the money for the iPhone that she wants or save for college, and now we're making it not a crime for her to do that? Is that
We
what
hope
you're
that
trying to
if a child
accomplish?
were to, I'm sorry, Miss. We hope that if a child were doing something of that nature, that there are authorities that would bring that child into one of these safe haven places, and really there's a problem with that child's, I guess, home life, school life, but find some other way of that child being treated other than criminalizing.
But my question is, we're now making it where that 16 or 17-year-old who we've said can consent to sexual activity is now allowed, without any fear of prosecution, to prostitute herself, where it's her choice to do so for whatever reason she chooses. And is that your intent, that you're wanting to allow these young children to be able to engage in prostitution without committing the offense and not be prosecuted?
I would say, Representative Franklin, no, we're not trying to open the doors for children to become more permissive sexually. We're concerned about the criminalization of their conduct, though, as minors, that many of them are not, I say far more, are not doing this on a permissive basis, but they're being forced by intimidation otherwise by adults, pimps, to begin performing criminal conduct as prostitution.
Right. I understand your stated purpose, but I'm still thinking of the way the bill itself is drafted. It would allow, would you acknowledge that it would allow a 16-year-old or a 17-year-old to engage in these activities without committing any criminal violation, engage in these activities voluntarily without any coercion?
Prostitution.
Is that so? You're
saying,
saying
no question, minors do engage in sexual conduct. The concern here is those who are being forced into prostitution, which is for monetary purposes, against their will. And I'm saying that there may be some that do that. But I say overall, the question we'll want to examine is the policy of the state. Is it better served having all of them criminalized, or trying to find a way to address what may be permissive conduct as prostitution by these minors?
And that let me just make sure we got clarity on it, because I think the exchange I just heard really frames the issue pretty well, and that is that as I read the bill, please correct me if I'm wrong, Mr. Chairman, as I read the bill, as a matter of law, any time the law will presume that any individual under the age of 18 engaging in that conduct is always a victim, and therefore a victim of a particular situation, and therefore would not be prosecuted. And if I understand the issue correctly, it is that, in presuming that, it obviously presumes that in every situation where prostitution occurs involving an individual under the age of 18, that at no time under the bill would is an individual considered to have been engaging in that conduct on their own without being a victim
as criminal conduct.
Right.
Yes, sir.
Okay. And I think that I hope that frames the issue in general, and it's certainly an interesting question. Mrs. Cooper.
Representative Willard, is the age limit now 16?
The age limit now is 17, is it? What is it? No age limit. Excuse me.
There's no age limit.
No age limit. Pardon me, that's correct.
So
the idea is to make an age limit.
okay, so any young female or any person that's picked up for prostitution, no matter what their age,
under 18,
are they prosecuted? No, not this bill, but are they now prosecuted?
Currently, they are subject to prosecution.
Okay. Isn't all of the research that's come out lately showing that there is a huge indication that most of this occurs because young people have been on the street and have been coerced by older adult males into prostitution, and this is the reason that they are engaging in this activity.
A lot of the study shows that, and you'll have some people testifying today about that.
Okay, thank you.
Mr. Bearden.
Just real quick, the age of consent in Georgia, though, is age 16, correct?
16, correct.
Thank you.
Mr. Sussler.
Thank you, Mr. Chairman. Chairman Willard, I'm just trying to get my mind around kind of the legal framework that we're in today, just as a basis of comparison. This isn't a leading question. This is a question. So juveniles 14, 15, 16 who are involved in this now, they're not adjudicated in the juvenile courts. They're actually subject to adult courts for this.
Yes, they are. 117 could be adjudicated in a regular criminal court. Under 17, they would be adjudicated in a juvenile court.
Right. I just want to confirm that, no, and that this may be a question for counsel. I don't know. If they are adjudicated in the juvenile court, is the charge, is it still defined as prostitution and defined as outlined in under, quote, criminal law, but yet it's adjudicated in the juvenile courts? Is that the...
I think a delinquency could be considered part of it. You have sometimes a framing of what it may be called the complaint in juvenile court, wording different from what may be addressing the violation of criminal statutes.
Okay. So right now for 17-year-olds, they're necessarily tried as a criminal statute, or is there a... I'm just trying to draw the line on my mind and understand existing law of how this is treated.
I think it would still, and please, Jill, jump in on this. I think even if we decriminalized the conduct that we talk about under this bill, a child picked up for prostitution would be brought in perhaps to juvenile court for treatment and otherwise to get help. The amendment we're going to pass out to the committee addresses going either into juvenile system, finding resources available to help, or through the Department of Family and Children's Services, means of getting to a safe house for help.
Okay.
And of course, juvenile laws are not considered, quote, criminal per se. They're more of a conduct prohibition.
The juvenile court only has jurisdiction up to the age of 17.
Yeah. So. At age 17.
But there is an overlap at 17, where at 17 they're subject to criminal courts, but also can be adjudicated. Is that?
No. It stops at 17 in the juvenile court. Well, there are certain things that juvenile court has continued jurisdiction, but for original jurisdiction, it stops at 17.
So for 17-year-olds, there are original jurisdictions in juvenile court?
No.
It's in criminal court.
Criminal.
That's what I believe to be the case. Okay. That answers my question, Mr. Chairman. And again, I did have a, and we'll hear a lot more testimony that will probably bring some more questions, Mr. Chairman. I'm just trying to understand the current state of the law. One last question. What is the current, for a 17-year-old who was engaging in prostitution, is this a misdemeanor, and what's the remedy? Is it a
misdemeanor, I think, to start with, and then you have graduated.
Does it carry up to a year in jail? Or is it just
any misdemeanor generally is going to be up to 1 year.
So it's treated as okay.
State misdemeanors, yes, sir.
Just following up on that, Ms. Travis, and talking about the state of the law and the ability of a prosecutor to prosecute an individual for certain conduct, either as an adult or as a juvenile. Currently, please correct me if I'm wrong, currently in a homicide, a prosecutor has the discretion, depending on the fact situation, to prosecute an individual under the age of 18 for homicide as an adult. Is that correct?
13.
Can
Okay.
be.
Can be. So, okay. And that comes down to a matter of prosecutorial discretion. and pursuant to the facts of each individual situation. I assume that's done in consultation with the juvenile court and/or the superior court, or from a mechanical standpoint. We'll talk to the prosecutors in a minute.
Yeah.
Okay. But getting back, so we have a situation where under this bill, depending on how it would be amended, ultimately, you could have a situation under the law where an individual could be prosecuted at under 18, could be prosecuted for murder, but under this bill could not be prosecuted as an adult for prostitution. Or am I understanding that correctly? Okay.
Mr. Chairman, I believe.
Hold on one second, Mr. Setzler. That leads me to the question of. It leads me to a couple of questions, actually. There are going to be some situations that are, getting back to the permissive discussion, some situations where this is a true victim situation, and there are situations where perhaps that is less clear and maybe not the case. That then comes down to a matter of prosecutorial discretion as to should this be charged or not charged. And I'm wondering if we take this conduct and say, as a matter of law, it is not this. It is not this. And that's pretty broad. And I'm just wondering, there are going to be fact situations where perhaps a prosecutor, in his or her discretion, sees that and says, well, that person's a victim, and there are others that say, well, they're not a victim. I presume that. I'm not a prosecutor.
And I think in talking with prosecutors today, we can find out, but I think they somewhat have that discretion now, perhaps.
Right.
So that is an issue to be addressed, and that's why I say it's a good debate for policy in the state, is how far we're going to change, and do we want to change.
One thing I would note, and this is just as a comment, in looking at narcotics trafficking, I mean, for the longest time, if not currently, again, claiming no subject matter expertise on it, you had these traffickers, these drug dealers, using juveniles specifically because they know that they're juveniles and can only get rung up to a certain extent. I'm wondering aloud, dangerously, if by virtue of defining these individuals as juveniles for purposes of prosecution, I wonder if we almost completely unintentionally almost augment the problem, because then these people running these prostitution rings know that these children can never be prosecuted as adults, and therefore make them more attractive in terms of putting forward their mass trafficking, human trafficking operations.
And
That's just
to respond to that, Mr. Chairman, that is also an opposite of what you are having now happen. That is, these adults keep these juveniles, children, in prostitution by fear.
Yeah.
But the fear is, we're going to have you prosecuted, or turn you in, or whatever it may be, and that is another way of intimidation to these minors. Of course, these are usually children who are in harm's way already for whatever reason, home life, school life, whatever it may be. They're needing help, and the problem is that barrier is put up by the fears that are placed before them, and not able to get help.
Mr. Chairman?
Let me. We'll go around the horn one more time. Mr. Franklin.
Thank you, Mr. Chairman. It's continuing where we left off, and I think Chairman Golick was said a lot more clearly than I was trying to say, that while I understand the talking points on this bill, and I laud those, child sex trafficking is an abomination, and those trafficking in children for sex, for anything, should probably be getting the death penalty, because it's that serious an offense. But what we have before us is not the talking points. It's the bill that just removes the youth from a prosecution for the offense of prostitution. The bill does not say that if you're under 18, you're a victim, as the talking points do. And my concern is that not only would it then be easier for those doing their trafficking to say, well, you're legal. You can do this. But those who should it be the policy of the state to say that a 16 or 17-year-old can voluntarily prostitute herself? And I think that's dangerous ground. Now, we have heard a lot about the coerciveness, which is what you're going after. But I'm certain, as a great attorney, you're familiar with Code Section 16-3-26.
Oh, I think you might.
I'm sure you've memorized the entire thing, Mr. Chairman, as have I, for the record, as have I.
Recollection on that.
Yeah. Yes, we've committed it to memory, absolutely.
Well, let me refresh. I've just printed this off this morning. A person is not guilty of a crime except murder if the act upon which the supposed criminal liability is based is performed under such coercion that the person reasonably believes that performing the act is the only way to prevent his imminent death or great bodily injury. And this is under the section of defenses to criminal prosecutions under Chapter 3 of Title 16. So right now, a young child is not guilty of prostitution because of this defense of coercion. So I'm concerned that we're being sold a bill that we're going to stop these children from being coerced into prostitution, when really what we're doing is we're legalizing child prostitution by the words of the bill.
That'd be a position to take if you want to.
Mrs. Cooper.
Mr. Chairman, to respectfully ask you, as one of the statements that you made earlier, that one of the issues that faces this committee is to find balance between protecting individuals and individual rights and not causing other problems within the law, that even though this bill or a similar bill you think might make it easier for people to use young people as prostitutes for their businesses, ultimately I would hope that we would look at the damage that is done to the individual that is being used and whether they should be the criminal or not, regardless of the other part, and that perhaps the bill or another bill needs to go out either even more severe punishment for the people who use them, but that we look at both aspects of that and not just one.
Yes,
because the person
I think we do that on every issue, honestly, to the infuriation of some, but I think it's a good approach. Mr. Sessler.
Thank you, Mr. Chairman. I mentioned, excuse me, I mentioned to Chairman Cooper a moment ago during this discussion that perhaps there ought to also be consideration for enhanced penalties for, I don't know if it's a term in Georgia law, is pimping a term of minors. But you know, the perpetrator here we're focused on really is the person that's creating this environment of coercion that's functionally enslaving these young women to these lives of prostitution. And I don't know that there's enhanced penalties for pimping of minors. And I don't know if there. I would ask counsel if there's a sort of an aggravating circumstance or if there's. But I would just offer as we consider this and we move forward that might be an additional supplemental remedy as we think through this, because I do, in my sense of justice, if you've got an adult that's, and again, even many adults who fall in the lives of prostitution are subservient in many ways, whether it's because of drug addiction or some other set of circumstances. But I think doing that to minors, again, I think that's really the crux of this discussion, is to shutting that down. And I think as a remedy to help shut that down, this committee might want to consider an enhanced penalty of some kind. Whether or not we would agree with Representative Franklin's characterization or not, and I think that's frankly a second issue. But I would just ask you to consider that as we move forward.
Good point. I agree with you.
If it's somebody under 18.
Okay.
Chairman Willard, thank you.
Thank you, Mr. Chairman. A closeout with there will be someone speaking from the Fulton County District Attorney's Office as to the proposed amendments, and I'm supportive of what they're suggesting too.
I think what I'd like to do, thank you for that reference. I think what I'd like to do is we'll call on the witnesses, and I really would like to go ahead and I try to go back and forth in terms of supporters and those in opposition, or those maybe somewhere in the middle who want to see certain changes. So with that reference, let me call on the Fulton County District Attorney's Office that's asked to go ahead. Ms. Yes, sir. Thank you. Ms. Deborah Espy, is that correct? Sure, Judge, come on up. We're happy to have you.
This has not been passed around.
Oh, okay. That'd be fine. Thank you. And let me ask you if you'd like to make some, Judge, if you want to come over and send the second, so if you do respond, you can respond to the microphone, or either one. And if you have any opening comments, that'd be fine. I would just ask you to please make it as limited as possible. I think our time is always best spent when we're engaging in Q&A, because that's when the issues really get fleshed out. So thank you and welcome. We look forward to your comments.
Thank you. And again, my name is Deborah Espy, and thank you for an opportunity to speak this morning on behalf of House Bill 582. Right now, the Fulton County District Attorney's Office, who's looked at these issues for a number of years, is asking this committee to consider some further amendments to House Bill 582, and we believe these amendments might clear up some of the issues that prosecutors have had across the state with regard to this bill, and we thank you for your opportunity to allow us to present them. Let me just say briefly, I have chaired the Crimes Against Women and Children unit of the Fulton County District Attorney's Office for about 12 years. And that's a group of prosecutors and investigators. We have one psychotherapist, and we have been dealing with these issues in Fulton County for a number of years. Not just us, but also the agencies that provide services to children have had to deal with them, and we've seen everything. We have seen, and let me just say this, what we're talking about here is forced activity for the most part, not voluntary entry into a life of prostitution. We've seen forced drug addiction, abandonment, homelessness, abductions, withholding of food, abuse by parents and relatives for purposes of commercially exploiting their own children. We've seen beatings, isolations. The children have mental health issues. They've been raped and sodomized. They have venereal diseases. It's my understanding that Atlanta is in the top 5 cities in the country believed to be involved with the spread of AIDS. And a lot of this is spread unwittingly by young people who don't know that they have the disease. We've seen everything. Children recruiting other children into the profession, children who have committed suicide as a result of what's happened to them, master dominatrix behaviors, and the whole gamut. We have seen it. And we believe, without repeating everything that you are likely to hear later on, that the answer to this question is to treat these children, and they are in fact children, as persons that are in need of services and care. And so as a result of that, we are proposing some further language for your consideration with regard to this bill. I will tell you that the average age that we see is a child between 13 and 14 years of old. We see some younger and some older. The older children, the ones that we're talking about in the 17-year-old range, didn't just wake up overnight and decide to do it. They had been recruited into this illegal activity much earlier and were afraid to come out. The children are threatened. The pimps have a process that they call trunking children. When they don't do what they ask them to do, they put them in a trunk, drive them to another part of the country. They get out, don't know where they are, put them on the street working somewhere else. They actually have networks. They're a lot more sophisticated than we are. They have networks, and they switch these children out. And so for fear of all of these things and more happening to them, a lot of these young people will submit. It's a survival technique. I hate to use the word Stockholm syndrome, but a lot of times they have to accommodate their abusers in order to survive. So I can tell you since 1997, this is what we have been looking at. And so that's why we are in support of this bill. One of the main problems that we find that the police are having is that, and you know, police are trained to care about victims. They see these children out on the street, and they can't do anything with them. They see them in areas where they know that children are being exploited. They're dressed in certain ways, and the children, because they have been trained by the pimps, will tell our officers, if you don't have a pickup order, you cannot touch me, okay? And so they're a lot more savvy and more smart because they're being trained by the pimps to stay in this profession. And so what we are proposing here are some things that we believe will be very helpful. Under ordinary circumstances, if a police officer saw somebody wounded on the side of the road, they would do something to help them, not lock them up. And so we're saying, why lock up these victims? They're victims too.
Let me ask you a question on that.
Yes.
And in the 30 seconds that I've had to take a look at that, which is fun, these proposed amendments, which is fine, and we'll take a look at it in the interim as well. What I'm seeing here is what you're doing or proposing language that gets into the specific fact situation where the officer has probable cause to believe that the exploitation is occurring.
That's correct.
So what I think I'm seeing and understanding, subject to being corrected obviously, is whereas on the original bill it would take any such conduct performed by anyone under the age of 18 and automatically presume that it not be criminal. These amendments, I think, are recognizing the fact that maybe that previous language might be a bit broad, and that this language goes into the specific fact situation of where exploitation actually is occurring, recognizing the fact that there are fact situations where exploitation is occurring, and there are fact situations where perhaps it's not. If you put a gun to my head and said, more often than not, is it going to be an exploitation situation? My answer would be yes. That's what I personally believe. But can I sit here in good faith and say that 100% of the time it's that type of situation? I'm hesitant to say that anything is anything 100% of the time. And the words on paper matter. So what I'm seeing in these proposed amendments is a recognition of fact-specific situation where you have such exploitation. Is that a fair statement?
It's a fair statement. It also goes a little further. It addresses situations where the officer has reasonable cause to believe.
Let me ask you another follow-up question to that. Under the law, do they not have that potential? Do they not have that? Does law enforcement not have that discretion now, and/or does the district attorney's office not have that discretion in terms of how they prosecute and how they don't prosecute under current law? In other words, I guess what I'm asking is this truly necessary? Doesn't the discretion actually exist right now as to how y'all go forward? We need to be educated on that.
Okay, I'm not real sure I understand your question, but I'm going to try to answer it, and I think there are two parts.
Well, I guess my question is that you're going to get a fact situation of an individual engaging in this conduct. They're under 18. They're under a certain set of facts. That may be a set of facts where this individual, the child, is absolutely being exploited. It is a victim situation. There's just no ifs, ands, or buts, and that's something that you, as a subject matter expert in that area, can recognize 10 times better than we ever could. There will be those situations where you and with your subject matter expertise on it will look at it and say, not so much. Right? Isn't that reality?
I mean, we have the discretion to make a determination.
Okay.
A fact determination in these cases as in any others.
How does your ability to to go forward on a particular charge on a particular individual now, in other words, why is it that under the law right now, what is it that's lacking in the law right now that prevents you from doing what you're proposing right here?
Okay, it starts at the point of detention. What is happening, as I indicated earlier, is the officers have to be able to feel comfortable with pulling these children in, okay?
Which they're unable to do right now.
They are unable in some certain situations to do it because, as you know, it's not going to happen just flat out on the street and open.
I don't know. That's what I'm asking.
Yes.
I mean, I don't know, and I have a feeling that a lot of the committee members don't know as well, and that's why I'm asking the questions from a procedural dynamic standpoint. So what I'm hearing is no, in fact, the officers cannot go ahead and do that. They don't have the tools necessary under Georgia law to do exactly what you're proposing. Is that correct?
What we're suggesting is that they need to be able to intervene at the point that they believe something is happening.
Which they do not have right now.
In some instances, they are not able to.
Okay. That's what I'm trying to figure out.
It's the nature of the activity.
Okay.
In some circumstances, they're not able to.
Okay.
And so what we're proposing is that officers be allowed to detain these children temporarily for their health and their welfare, and to bring them to assessment centers without going through everything, and places where they can receive services. They have a lot of needs. Also, we're asking that within 48 hours of the time that they are taken to either DFACS, the juvenile court, or these centers, that they're assessed, and DFACS is notified for purposes of determining whether or not to bring deprivation proceedings, because many of these children do fit the category of deprived children. Okay.
Let me, if I could, Ms. Espy, can we get segue into questions, because I think we're going to.
Okay.
I think it gets right into your comments, so it'll be a good segue. Mr. Knox.
Thank you, Mr. Chairman. Follow up with the Chairman's question there. Aren't we really here trying to get at the issue of an officer not being able to determine whether the person's under 18 or not? I mean, you can't walk up to somebody always and say, look at them and tell they're 16 or they're 14 or whatever age they are. Oftentimes, you know, people could make themselves look older by how they dress and, you know, makeup and so on and so forth. Isn't that the real core of this issue here, that y'all want to be able to eliminate the necessity for the officer to make that decision and to be able to have actual probable cause for determining that they're under 18?
That is part of it. What we're trying to enable the officers to do is to have reasonable cause to make a determination that the person may be a child, and then based upon what they see, take the appropriate steps. I'm not sure that I'm answering the question. I'm sorry. Do you understand?
I guess.
Let me clarify just two things here. The reason that the amendment says reasonable belief is because there's an assumption that there has been a change in the law and the person is not under arrest. There was a concern that if they see people doing things under current law, in order to make an arrest, you have to have probable cause. This particular amendment would allow an officer with a reasonable belief that something is going wrong to actually pick up a child. We've had children who have been on the street that officers have approached, and they have said, where is your pickup order? Now, the age that we are addressing really, as I heard from some questions, is age 17. Because if you're 16, the officer under the juvenile code is clothed with the authority to pick up a 16-year-old, take them to get the services they need, because under the law, if a juvenile has committed what would have been a crime by an adult, they can be charged as delinquent. So a 16-year-old is out of it. 17s fall within that gray area, and this would allow the officer to treat a 17-year-old the same way without charging them with a crime. If there's probable cause to arrest, at this point there's an arrest charge made. The 17-year-old is taken directly to jail and may plead and get a fine or what have you, but nothing in the law triggers any services to them, and that is where that's one of the major concerns we're trying to address.
Mr. Knox, did you have any follow-up?
If I could, maybe
Sure.
I didn't make my just one other. So am I hearing you say that this is not an issue about the problem that you're having picking up children, female children in most cases, I guess, in certain neighborhoods where there's evidence that those kind of crimes occur? If you go in and you can't take them into custody, regardless of whether they've been arrested or not, but you can't take them into custody unless you know they're under 18. And if they tell you they're not under 18, you can't take them into custody, correct?
Correct.
And so this addresses that issue, that you can take them into custody and you can find out later whether they're 18 or 17 or 16 or whatever it is, and you don't have to jump through the legal hoops about probable cause for picking somebody up when you don't know how old they really are.
That's correct.
Okay.
And more so in this environment than neighborhoods, we're talking about hotels. I wanted to make that clear. When children are brought into Atlanta, whatever their age, they are now, under Craigslist, taken to a hotel as much as we have people being on streets.
Mr. Sethler, and we'll come around this way.
Thank you, Mr. Chairman. What's the, and again, you know, we're trying to strike a very careful balance here between, you know, and empowering our officers to do things that they should do and making sure we're not, you know, sweeping the streets clean with people who, you know, we've got to strike the balance. What's the standard under juvenile law here in Georgia to determine? I mean, in fact, your counterpart mentioned a moment ago that Georgia juvenile law gives officers the authority to go pick kids up and take them in using well-advised discretion to take them in under some blanket delinquency.
Right. Well, under
portion.
juvenile law only applies to 17. Let me answer the first part of your question if I can. 16. Under 17, which means 16 years and under,
sure,
there's a much lower threshold than probable cause.
And that was my question. What is the current threshold that they've got to meet to take a child in?
Reasonable belief that the child is deprived or has committed a delinquent act.
Now, is that the same, again, as a non-attorney?
That's pretty wide.
That's the same standard that it takes to pull someone over? Is that the same standard? To pull a car over and talk to someone?
That would be probable cause.
You don't need a full probable cause to pull a car over and stop them.
If you're just doing a regular, are you mean for a license check or something of that nature?
Yeah.
Okay, well, that would be different.
Yeah.
And again, I don't want to get into too much legalism. I'm just trying to understand, if you could help me kind of understand the elements of that threshold we're trying to get to, so I just have a sense. Because what I hear you saying is the same threshold that's applied to juveniles we're trying to apply to 17-year-olds. Is that a layman's way of describing? Okay. Mr. Chairman, that was my question. And again, just in conclusion, my concern was only that we have that there be some standard, that it be an appropriate standard, that it not be so high. I think, as I read your handout here, a law enforcement officer who has probable cause to believe, am I to understand that currently, to determine that you, quote, have probable cause, it requires an order, a judicial order of some kind to determine that? Is that not the case?
No, that is not the case.
That's not the case.
Right.
So there are certain contexts when officers are determined to have probable cause, and that would be the same standard, say, to enter a home or something like that?
Right. That's the probable cause to make an arrest. And 17-year-olds at this stage are considered arrested. The language for juveniles is different. They are detained.
Thank you.
Mr. Bearden.
You caught me with a phrase that shows some concern, because we're talking about people under 18. Of course, we're talking about 17 that can be put in regular court or adult court. Articulable suspicion and probable cause are things that's been defined under the U.S. or the U.S. Supreme Court. Probable belief is something I don't recall ever hearing. Now, if the officer has belief a child's life is endangered, when they're in a home, they can pull that child out and get them to that protective agency. So I'm just a little bit concerned when we start talking about probable belief. Are we, if you're an officer around the Constitution?
You've hit the nail on the head. The reasonable belief that this language mimics the deprivation language. So now under state law, we give an officer authority when a child is in danger, in need of health and safety, upon reasonable belief, to take them into custody. This is the same standard, because the amendments actually, what this legislature has done is to, within the child abuse statutes, the child sexual trade statutes, child trafficking statutes, made the age of 18 for purposes of victimization. This allows those children to be treated as deprived children or in need of supervision, or to get our health and safety concerns.
So this language here basically mirrors the deprivation language?
Yes, yes. One assumption, I think, was that the amendment, and these amendments are in addition to withdrawing the language of 18-year-old. I think that was some discussion with that.
Right.
We are supportive of the bill.
Could you not
with the proposed amendments?
With the proposed amendment.
May I have one follow-up?
Yes, sir.
Could you not treat them as private children under current law right now?
No.
No.
No. Someone used the analogy of the murders. Under the juvenile code, murders, children as young as 13 come straight to Superior Court. Children 17 and above, 17-year-olds now, go straight to state court, a misdemeanor court. So there is an arrest. There is not so juvenile court under Georgia law has no jurisdiction under age 17 unless the child is under 18, alleged to be deprived, or a status offender.
Okay. Thank you.
Mr. Franklin.
Thank you. At the opening of your handout, you say that the Fulton County District Attorney's Office is committed to the notion that children who are victimized by predators should not be recriminalized by labeling them as criminals and so forth. Hopefully, the Fulton County District Attorney's Office would be aware of Code Section 16-3-26, knowing that if these children are coerced, then they have not committed the offense, and therefore the Fulton County District Attorney's Office would not be bringing charges. And hopefully the DA's office is aware of that code section. But in light of that, and I noticed that even you have in bold print that you want to go in addition to legalizing child prostitution. You want to add this language in your handout. I think I'd be more comfortable if you would propose your handout in lieu of legalizing child prostitution, and that would, particularly since the DAs would not be prosecuting these children who are coerced, and rather than the bill as it stands allowing for the voluntary prostitution of children, or children to engage in prostitution voluntarily.
The code section that deals with the defense of duress, which is what you were talking about, is actually consistent with what we're doing here today. It's very consistent with it, but the fact of the matter is these children are actually being charged with prostitution. They're being charged with prostitution, and their cases are going either to the juvenile courts, or depending on their ages, if they're 17 years old, they will end up in probably the state courts. So they are, in fact, now being charged. But the code section that you cited is consistent with what we're trying to do today, which is saying, that these kids many of them are coerced into this. And so rather than just having the defense there sitting on its own, we're saying that what you can do with this statute is to make sure that they're not charged.
Right, but my point is that since that provision is already in state code, that they have not committed the offense because of the coercion, that the original bill would not be needed, because it does allow for children to voluntarily prostitute themselves, and hopefully that is not a position that y'all would want to see happen.
It's, if I understand it correctly, for clarity, it's a defense to the it's a defense of the charge itself. It doesn't preclude the charge from being brought. Correct?
That's correct.
Okay. Let me get clarity on a question actually Mr. Franklin had, and that was, I want to make sure I've got your position clear. Is it your contention that we should have the bill as originally drafted, adding the amendment, or my sense from the language of it is that it's in lieu of the original draft, correct?
It would be adding, I guess you could say in lieu of, or in addition to, either way.
The wording in the handout says, therefore, in addition to the proposed change, which would be the change made in the bill, we would then redefine this.
Yeah, I mean, from the conversation before, from the questions I asked, it was more along the lines of, rather than the broad brush of everybody under 18.
Yes.
Absolutely. It's a fact-specific situation, giving law enforcement the ability that they need for the in-between situation of 17 that you said, Judge Hart, and as a result of
we actually proposed it with the idea that the age would be elevated to 18. But for those people who had questions about not being able to do anything with the children, or people who were 17, they would in fact have the opportunity to do something they don't have to do now. They don't have to now. With the 17-year-olds, the police do not have the option to take them to DFACS. They do not have the option to take them to even the child assessment centers. Under their protocol, they take them to the police station to be booked. And there were two concerns there, which we've also addressed in here, and that is, someone asked the question about enhanced penalties. This legislature has, in fact, enhanced the penalties for pimping and pandering a child.
Under age 18.
Under age 18. And so the concern from a prosecutor's standpoint, because that child is a major witness, is being able to keep their hands on that child and being able to, in fact, get that enhanced penalty. And so from our standpoint, that would enable us to do that. if in fact we could find out about the child, call the child as a material witness, and make sure that we did get the enhanced penalty for the pimping person.
Mr. Hatfield.
Thank you, Mr. Chairman. Testing. Am I on?
Yep.
Okay. A couple of questions. One, with regard to the issue of deprivation, am I correct that juvenile court has jurisdiction for purposes of deprivation proceedings up to age 17?
Actually, up to age 18.
Up to age 18. So, are you saying that under current law that these children that are placed involuntarily into these prostitution situations could not be considered deprived children under current law?
We had a debate about that. There's a difference between procedure and substance, okay? And so but currently the first stop for a 17-year-old is jail. Now, if an officer arrested a 17-year-old on the streets without some bruises, abrasions, or what have you, or some just extreme matter in terms of being starved or something like that, the officer's procedure would be to arrest if it was strictly a prostitution. We believe that the laws have changed, but this helps to catch up with the law. For example, the child abuse reporting procedure has changed, and it includes all reporters and people under 18. So, yes, but there's nothing in the code that triggers that. And you may be aware we can pass all kind of laws, but if there's nothing to trigger it, then this would enable the officer to trigger that.
Well, with all due respect, it sounds to me like really the issue is not whether or not we need another statute, but it's a matter of training the officers to say, hey, we've got a law that deals with deprivation for children who are deprived. And I think, I've seen a lot of different situations where children have been alleged and found to be deprived, but I in my opinion, under current law, clearly that a child would be or could be found to be deprived if they were in a situation where they were involuntarily being prostituted. Now, I'm maybe going out on a limb there, but I'm just saying.
You would be stretching the interpretation of current Georgia law, because procedurally, although, and we know in practice there's a difference between practice and procedure, and under the law, because of the jurisdictional issue, the first matter that a court inquires into, a person inquires into, is a matter of jurisdiction. And jurisdiction in Georgia is one of 10 states that takes 17-year-olds, clearly takes 17-year-olds out of juvenile court jurisdiction.
Okay, but you're talking about for criminal purposes. Okay, we're in two different realms. You've got criminal law, and then you've got juvenile law. And when we're talking about an allegation of a deprived child, the juvenile court has jurisdiction to take that up, as you said, up to age 18. So my point is that if the officers, if your concern is that these kids are being arrested and prosecuted, then the officers and law enforcement agencies need to be redirected to say, hey, don't take these kids into custody and charge them with a crime, but you go down to the juvenile court and you fill out a juvenile complaint form and
that's exactly what our proposal. That's exactly what we propose that happen. But because Georgia law currently creates a crime for people under 17, that is not clear.
Okay, but I have to sort of follow up with Representative Franklin's comments that essentially by wholesale exempting those under age 18 from the operation of these statutes, these criminal statutes, you are also allowing those that were to be under the age of 18 to voluntarily engage in that sort of conduct, and giving the state is saying that's okay. I think you have to strike a balance, but maybe the way to do that is we create some specific defense that's built into these statutes dealing with a situation where it's pimping or coercion is involved. But I just don't see a wholesale exemption for those under age 18, because that's presupposing that there's no kids out there under age 18 that would voluntarily violate this law. And while I think that's unfortunate, I think that there probably are some.
Okay. Our experience has been that, as Ms. Espy said, that a person 17 doesn't just start doing that. That person probably at age 16, maybe at age 15, had some impact into their life in terms of grooming or what have you that brought them to this defense. Now, once they get into without getting into what happens with misdemeanors where you get charged, you get a fine, you're immediately out of jail. There's currently within that no provision for services. And our concern at this point is for services. But the second point is for the criminalization in terms of the record. And so, and it is a policy decision, of course, that as Chairman Willard said, it's for this legislature.
I would just like to I'll wrap it up,
Yep.
Mr. Chairman. But I agree with the intent and the spirit of what you're trying to do. I guess what I'm saying is I believe that could be done administratively without the enactment of new statutes. But I think it could be done under current law.
Yeah.
Or under the context of the amendments without the blanket presumption of under 18.
As long as there's a clarification, and I'm putting on my other hat now because I have to argue this jurisdictional issue of appeals all the time.
That's why we're doing this in June.
As long as you have, as long as there's a clarification with regard to jurisdictional issues, and because that's something that's pretty firm in the law, and it's like, okay, we hit here first, and then we back up.
Ms. Benfield.
Thank you. I have a main question, but I would just want to follow up on the commentary about the possibility that a woman under the age of 18 could voluntarily engage in prostitution. Isn't it akin to the statutory rape provisions where, what's the cutoff for statutory rape? Is it 16? I'm just thinking, the law says you do not have the mental capacity to consent to a sex act if you're 16 or under. So I was thinking along the same lines for prostitution, that below a certain age, the law would recognize that you cannot consent to that type of activity.
I think Ms. Espy's experience with prosecution of these cases, is that the person's consent is flawed.
Yeah.
Just because you're of age doesn't mean that you do. We have what we call an informed consent. I think that's part of the language, informed consent. If you have been abused, intimidated, drugged, all of these kinds of things that go along with this behavior, it's kind of an oxymoron to say that when you get to age 18, you in fact voluntarily consent.
Sure. And if I might add to that, many times the predators that are involved in this are more than twice the age of the 16s and 17-year-olds. They just absolutely have no equal bargaining power with these men. They just don't have it. And so our experience shows that they are victimized and they are in need of care. They're in need of care.
Now, thank you for that. And the main question I had was, would another way to address this issue be to simply raise the juvenile court jurisdiction for delinquencies to age 18 as well? I mean, or is that too broad a swath to address the issue?
I don't know if the legislator wants to address that, but I did some research, and Georgia is in the minority of states who don't get into this.
10,
there are 10
10
states that have age 17. There are 2 states, North Carolina, another state, that actually have age 16, and there's a big debate going on there. The rest of the states, 37 states in the union, have 18 as the age of jurisdiction for juveniles. Can I
just a brief follow-up on that? Because now Congressman Lynn Westmoreland and I actually co-authored the bill that raised the deprivation to age 18. So I'm an advocate for increasing the jurisdiction juvenile court. Now, the courts may not want that, given some of the funding restrictions. But I do think that's one way to look at this issue, is just raise the age of 18 for juvenile court jurisdiction for the delinquency of offenses as well.
Well, it creates problems and issues both ways, but right now we just think that this would be a good start for this particular set of victims.
Ms. Abdul Salam.
Thank you, Mr. Chairman. Thank you all so much for being here today, to all of you. Just a couple of questions. It seems to me that in experience with juvenile issues and working with missing children who are often found to be kidnapped, if you will, and taken other places, they're forced to be into these enterprises because of psychological, physical, and other threats. And the issue that I have with jurisdictional things is that from one county or from one jurisdiction in the state of Georgia to another, these are handled differently. And I think that the only way to do that is to codify it by state law. So I would just, in terms of whether or not it's something that can be done under existing law, if that is the issue, then my question would be, why isn't it already being done?
Mr. Collins will have the last word on this panel.
I hate to tell you,
Mr. Levitas.
Chairman, it's me. That's why I sat here. I knew you might not call me otherwise. In the words of my esteemed chairman, I don't want to get too far afield on this, but I do want to, since Representative Benfield made the comment, let me preface all this by saying I like the idea of your bill, and I think for too long we focused on these young girls or young women, however you want to look at it, as criminals rather than victims. So I applaud what you're trying to do. And I say that as someone who is adamantly opposed to raising the general juvenile age to 18. I think that at 17, somebody who has a gun has a pretty good idea that they're committing an armed robbery. That said, my concern actually has to do more with the civil rights of these young women. And specifically, I'm talking about A4. As I read it, and I apologize for being a little bit late, maybe I'm misreading this, and everybody on this panel will tell you that wouldn't be the first time. But as I read that, it says essentially if an officer looks at a young woman and in his or her judgment that person is under 18, and if they happen to be in a high prostitution area, let's say on their way to go get a gallon of milk for mom or dad, they can be thrown into juvenile. Am I misreading that? Because if that's the case, I obviously have a lot of problems with that.
Yeah, you are actually misreading it.
Okay.
What it basically says.
I told you it wasn't the first time.
The officers who deal with these kinds of issues are very well attuned to conduct that is suggestive of this kind of behaviors. And what they're going to be doing in this case is basically like they would do in any other case. They're making an inspection to determine if you've got a victim here. And so it's not going to be a civil rights issue. Remember where the children are being taken. They're not being taken to, under this scenario, to the police department. I
understand.
They're being taken someplace where there can be a further examination by people who are professionals, who are attuned to behaviors and needs. And if, in fact, there is no need to provide these services, then that person obviously is not going to follow along the balance of this track.
All right, let me just follow up with you very quickly. If you look at A4, beginning with a law enforcement officer who, and the number one is has reasonable cause to believe based on the person's appearance or admissions that he or she, in fact, is under the age of 18. That's number one. Mm-hmm. Then number two is the officer observes the person in an area known to the officer as a place where sexual exploitation of minors has occurred during the time of the day the officer observed the person. Then it moves on to shall, for the welfare and safety of the person, immediately detain and deliver them. As I read that statute, it says, one, if you believe them to be under 18, two, they're in an area where the officer knows there to be prostitution. There's no, are they engaged in anything, have they done anything, and there's no option for the officer. That officer shall immediately engage in the rest of the paragraph. And as I read that, you can be in that for perfectly lawful purposes, and all of a sudden, for no fault of your own, be in the right place at the wrong time, you're going to have this code section apply to you. Please tell me how that is not the case. I understand what you're saying. Once they're down there, they won't be in any more trouble. But if I sent my young daughter out to go get some milk for me or whatever it is, and she happens to be there, an officer happens upon her, according to the statute, she's got to go down to the juvenile court.
All right, I guess the analogy that I would make to that, and I don't know, Betty Ann, if you want to chime in or not, is that I could be lawfully proceeding down the road in my vehicle. I'm just trying to give an analogy as best I can and hopefully address your concern. And a police officer could pull me over for perhaps, let's say my tag light or something is out. He has a right to pull me over because of something that he sees. He might, in addition to that, determine that he wants to ask me for my driver's license. And if, in fact, my driver's license, I don't have it or is suspended, he could take the appropriate steps. I guess what I'm saying, to some extent, that this is a training issue. And I would agree with those who say you always have to train in addition to make sure that the law covers everything. It's a training issue. Based upon the fact that my light was out, he has a right to make an inquiry. Based upon an experienced officer's knowledge of the areas where these activities take place, what he sees in terms of what's going on, and generally what they see are children congregated on corners. They may see automobiles passing by, conversation between the people in the cars and the children. Based upon what he sees, this allows him to make an inquiry to see, is there something further that needs to be done, okay? And so this is what we had in mind when we framed this. And again, it does not require him to do more than to make the inquiry, and if in fact he makes the determination that there is a problem, then he needs to, at that point, it says he shall take this person
Ms. Espy, what you've described in your comments just now, we're going to have to excuse y'all because we have other witnesses, but what you just described in your previous statement just now had an element of conduct to it, and a close reading, I think I would agree with Mr. Levitas' close reading of that bill. It would force the officer to go ahead and just pick that person up as opposed to conduct. But that's why we have the amendment process, and if this bill were to go forward, I think there would have to be some element of conduct that the officer observes prior to taking X action, whatever it is.
Yes.
Let me thank you.
May I give you a case?
No, I'm sorry, but we have to move on.
I was just going to give you the case that showed what that.
We got 6 months.
Okay. Okay.
So, and I'm not trying to be cute about it. It's just that we do have to move on. I want to thank you both for. I think it's a very productive.
Thank you
Q&A.
for your time.
Thank you
for
your time. We appreciate it. I'm going to ask. We have several more witnesses. I'm going to ask you, please, to limit your comments to 3 to 5 minutes, if you would. I think this issue's been fleshed out pretty well. That, by the same token, people need to be heard. And if there is something new that we've missed, or that any other witnesses missed, please don't hesitate. Again, we have plenty of time in the interim, and if there are new ideas and that need to come out subsequent to the hearing, where we are around. Let me ask Sergeant Ernest Britton from the Atlanta Police Department to come forward. Sergeant, we welcome you, and we thank you for your service on behalf of the Atlanta community. Welcome.
Welcome. Glad to be here. Again, I'm Sergeant Ernest Britton with the Atlanta Police Department, supervisor of the Child Exploitation Unit. Among many of our tasks, we directly deal with investigations dealing with child prostitution and those exploiters of the children. Not to repeat what's been said, generally my involvement, or my unit's involvement, is dealing with the victims. These are the young ladies being used for monetary gain. And there are terms thrown around of voluntary, involuntary, willing, forced to. And to give you an idea of what we're dealing with, we have juvenile girls who are involved in a trade. And when you say voluntary, you're saying that a child who may be educationally delayed from a very stressed childhood of being victimized, sexually abused in the home. We're saying that this child voluntarily has the capacity to come up with renting hotels, locating a spot to set up, to travel from one state to the next, from one county to the next, to rent hotel rooms under the age of 21 without a credit card, to be able to set up websites to advertise, to be able to get cell phones to change them out. We're saying, when you say voluntary, we're saying that this child has the capacity to put together a very major operation. I have not run across a child with that type of dynamic involved in prostitution. I have run into victims who will vehemently tell me they have no pimp, that they are doing this on their own. But yet when I find their journals and their diaries, because they do keep them, page after page I always say, I want to get out of this, I want to stop, but quote unquote, daddy won't let me. And daddy is always the pimp. I don't know of any child who has a stable home, making grades, A's and B's in school, having friends, going out on the weekends. I don't know of any one of those type children who voluntarily turn to prostitution. What I do see are children who come from troubled homes. Mom's boyfriend is abusing them sexually, or the uncle, or the cousin, or someone over the years have done something to the child that has never been addressed, and the child is now lashing out or rebelling from that abuse, and they feel that their own worth is only in their bodies, and someone coming along, whether it be another female or male, convincing them that that is their lot in life, to only be used for someone's sexual gratification. I have not had a chance to read the whole amendment, and I've only briefly read the amendment to the bill. But when we talk about, are we saying we want to legalize prostitution or legalize child prostitution, that's not what we're trying to say. What we're trying to say is we want to try and get these young children help. And as far as giving a green light to those exploiters, we do have, and within my unit, we do have laws, and we do go after those who exploit these children. So they know that there won't be a wholesale open season, that they will have free reign. We still will be prosecuting them for putting the children out on the streets.
Thank you. We'll take some brief questions. Mr. Hatfield.
Thank you, Mr. Chairman. Sergeant, are you telling me that under current conditions, if you find a child that's been engaged in prostitution and you find a journal that says something along the lines of I don't want to do this, I can't get out of this, etc., that what would prohibit you from going and filing a petition with the juvenile court alleging that the child is deprived? What is there right now that prevents you from doing that?
I'm glad you asked that.
Thank you.
Juvenile court. Within Fulton County, there is a intake process of a point system that we must meet before they take a child into custody.
That's not established under state law, though, is it?
Nope.
You mean Fulton County is doing that on its own?
Yes, just because of space. So we have a problem with Fulton County juvenile intake with space issues with this particular group. Now, usually with my unit, when we want to take someone into custody for that purpose, there is a lot of prodding, a lot of threats, a lot of begging to get them to take the child just off of that. It does happen, but that process has taken a long time to build up. Now, going to the journal, that's something that my unit is trained in what we do. If we're talking about another jurisdiction, they may not go that extra step to look for such a journal.
Well, and I don't mean to cut you off, but I know that the chairman's pushing us on time. But so we got some specific issues in Fulton County that might be a barrier to being able to handle these cases through the juvenile court.
Correct.
Okay. The other question I have is, You would agree with me that you mentioned a lot of factors about that a child couldn't do, like setting up a hotel room and website and all these things, which I understand and I agree with it in those types of cases. But you also would agree with me that the prostitution statute only requires that you perform or offer or consent to perform a sexual act in exchange for money or another item of value. And that is something that a person under the age of 18 would be capable of doing on their own without regard to a website or a hotel or anything else, right?
Well, and to make sure I clarify the answer, because that comes up a lot. Now, there's a difference between someone who may, let's say, be approached by someone, and during the course of that encounter, if a sexual act takes place and afterwards money is given, as opposed to a negotiated working, this is what the whole deal is. And you have to understand that the process is very territorial, meaning one girl can't walk up on a street that, let's say, a pimp has girls out on and just do what you just described. They will not allow that. So in that respect, they can't do it the way you're describing, meaning they can't be at an area that is known for prostitution where there are pimps and not have one.
Well, all I'm pointing out is and I'm not trying to minimize the problem at all. I think there is a problem. I'm saying I think that under current law that it's something that can be addressed through the juvenile system. But two, what I'm pointing out is that by changing the prostitution statute wholesale like we're talking about, that there would be certain types of conduct that go on that are voluntary types of conduct that would not be punished. And you could have prostitution that would take place in a private residence just as easily as it could take place in a hotel or at some predetermined location that's set up on the street, right?
But the only problem and my response to that is, if quote unquote prostitution had taken place in a private home, law enforcement wouldn't be privy of that. If we find out the prostitution is taking place in a private home, there are other laws on the books that we can address that will deal with that as well.
Okay.
And if the child does not have to be charged, meaning we can stop the prostitution even in a home, because the last I checked, it's very difficult for a juvenile to own a home.
Thank you for being here.
Mr. Sessler.
Thank you, Mr. Chairman. I appreciate you coming today, and I appreciate what you do. I'm not just saying that for window dressing. The previous witnesses from the DA's office, and we're honored to have a judge with us today, talked about putting tools in the toolkit of officers to be able to pick up the young women who need to be picked up, brought into custody, and dealt with appropriately. The victims, rather. Could you speak to, purely for folks, young ladies 16 and under, within the juvenile range we've talked about? Could you speak to the tools that officers have today legally with respect to a reasonable belief that they're involved in prostitution, being able to pick them up, take them in? I don't want to get into the issues of whether or not certain counties keep them, maintain them, and do right by them after you've taken them in, but with respect to the officer's ability to take them in, detain them, and get them off the street, do you have the statutory, the legal tools under Georgia law to get those young ladies, these young victims off the street today?
No, we do not.
Okay. What are the kinds of things you need specifically to? I mean, as a practitioner who does this every day and supervises, what kinds of specific tools do you need to be able to do that more effectively?
Basically, we would need that once we have the reasonable belief or the articulable suspicions that something is taking place,
Mm-hmm.
we need to have that authority to be able to intervene and either take the child into custody as far as taking them to a shelter or to juvenile court. Currently, we cannot do that, meaning, and they talked about the pickup order. You have to understand that many of our victims do not have a stable home. So if the child is gone for 2 or 3 weeks, they have not been reported. There is no pickup order.
Right. So to your point, the notion that the deprivation statute under Georgia covers this may philosophically be true, may be legally true, but in practice, the practitioners don't recognize that, and that's not, in the practice of law enforcement, that's not relevant.
Correct.
Is what I'm hearing from you. Okay. So perhaps as we consider this as a committee, and I'll make it quick, Mr. Chairman, as a committee, what Fulton County suggested is we be very clear in taking that deprivation kind of framework and applying it very specifically to the cases of juvenile prostitution, to make it very clear to you that you've got the ability to make those pickups. Okay, that's one thing. If that were provided, if that framework were taken from deprivation, provided specifically to address the kinds of cases we're talking about, if they were provided to you, the wording were gotten right, so Representative Levitas' concerns were addressed adequately, that would have a major impact from what I'm hearing you say.
Yes, it would free us up that if we engage a juvenile on the streets, that we know to be involved. We do not have to wait to see what other people have done.
Okay.
Meaning they have to check to see, has the child been reported missing? Has someone decided that the child needs to be picked up? Will DFACS take the child into custody if we say that this is what we believe? That is a process, a very long, very hard process, because at 2 o'clock in the morning, you'd be surprised how hard it is to get someone on the phone.
Okay. So having said that, Mr. Chairman, one last question. I get what you've said about the framework and the legal empowerment and the burden of proof for the officers. Setting that aside, let's say for a moment that did not, for whatever reason, that didn't happen, and all you had to stand on was the current state of House Bill 582, which says anyone under the age of 18 who engages in these sex acts is not guilty of prostitution. If that alone, without the provisions and the burden of proof things we talked about, if those things weren't provided, but all we did was decriminalize sex acts for people under the age of 18 with respect to prostitution, would that by itself solve your problems? Or do, in fact, what we're really looking for is this tools for police officers?
It would not solve the problem in that all it says is we won't arrest them. We won't charge them. But that does not solve the problem of what do we do with them. It's not enough to not lock them up and leave them where they are. That's not, I'm hoping, is the point of the bill. The object is to give us an avenue that when we contact DFACS, juvenile courts, what have you, that we say, this is what we believe, this is what we have, you must take this child. That's what the law says. And that's what we're looking for, because now it's up to the discretion of who we call, even if we have a pickup order, what to do with them. Meaning because the pickup order has to be specific as to where we return the child.
Mr. Emerson.
Thank you, Mr. Chairman. Just briefly, thank you, Sergeant Britton, for your work and the previous speakers there. This is a cancer on our society, and I'm optimistic that this committee, along with the author of the bill, Chairman Willard, will reach an amenable solution to this, to come forward with some legislation that's going to address this, but not allow continuation of this activity and punish those who do this, as well as punish the sharks who are out there perpetrating this on our young people. But I hear a term that's thrown out there quite often here, and I just want to add your professional opinion here. What percentage of males fall into this category? We keep speaking about females. Are males not falling into this category as well?
Males are in that category. Generally, when we deal with males, their setup is a little different, meaning most of the males we come across when we're working with them, they work in packs to protect each other. Now, there may be someone in the pack who becomes the dominant person, but generally what we see, especially if we have underage runaway teen males, their grouping is that they get together and they may welcome someone into the group to go out and perform certain acts, and they get grouped together. So it's very difficult to find a one person in that pack who's running the show. we do eventually figure out, sometimes when we have run across those instances, there is one person that we can point to. But for the most part, if they're on the streets in that manner, there's a group. When we do have an adult manipulating the situation, there is a, and I hate to use it, but like how they talk about terror cells. There's usually 4 or 5 adult males who have underage boys, and they will literally trade the boys within the group. So when we're dealing with young men, we have a whole nother dynamic as far as with an investigation, because we have to find out who's all involved, and that's a very long and intense process, even more so than what we have with the females.
Thank you, Mr. Chairman. That's it.
Ms. Banfield.
I have one question on the training, which I know is very key to law enforcement's efforts in this regard. And Atlanta Police has training. My question is there statewide training on child exploitation? Does Post require some type of child exploitation training, or is that done solely on a police department by police department basis?
It's more so done solely on a need of the individual officer. There's not a lot of training offered within the state. That has picked up over the years. But as far as I know, it's not part of mandate training. It's not part of post training. Much of the training that is offered is more of, it's not pushed within the department. It's one of those, you find an officer who sees it on his beat or his or her beat, and they want to know more. So they want to find out more. I routinely get calls from other jurisdictions, other investigators that I work with, asking me, how should I handle this? What should I do? What's the route? I even get other federal agencies calling me, asking me, how should we proceed with this case? So there's not a lot of training on this particular group of victims that we're dealing with.
Thank you.
Ms. Abdul Salam.
Thank you so much. Thank you so much for being here, Mr. Britton. Just arrived this morning from a conference over at Morehouse School of Medicine, and the topic was in terms of reentry into the community of convicted felons and people in the prison system. And one of the major topics of discussion, along with the people there from Department of Corrections and others, was prevention. That in terms of overcrowding the systems and the need to build more and more jails and prisons, one of the best ways to deal with that would be prevention. I guess I'm curious to know, of the young people that you all are taking off the streets, and with the remedies that are available now, they're actually arrested and some prosecuted. How many, or do you know, how many actually end up being put back on the streets, you know, without maybe being found not guilty or turning state's evidence against the pimps or whatever, whether or not that's clogging up a system unnecessarily?
Just to be clear on the question, as far as with the young ladies that we come across that I deal with, we do not charge them or we do not prosecute them for prostitution. With that said, all of the young ladies that we come across, we try to divert them to social services or assessment to find out exactly what their needs are. I work very closely with the juvenile courts CEASE program, Justice Without a Fund, or Not a Future, Not a Past at this point. I work with the Salvation Army and numerous other groups that I try and work with as far as with getting the young ladies help. What we do once we do that is we gather as much information that we can or that they're willing to provide. And then that goes into us seizing journals, mapping their paths as far as where they've been, who's been around them, and we build our cases that way.
Okay.
So we are not clogging up any criminal system with our victims. We are trying to clog up the system with the exploiters. Yeah. And generally with our cases, we take them federally as best we can, and they are getting anywhere from 10 to 25 year conviction. So if we can overcrowd the jails with that then I'm happy
Fine.
with that too.
And the reason that I asked that is you were talking about the point system, and you were talking about space issues, and spaces being available. And so the spaces are not being taken up by people that you guys have taken off the streets. You're
Right,
putting them
meaning-
elsewhere.
Right. Meaning, when I say point system, meaning when we call and want a child detained for delinquency or what have you, they're looking for a criminal charge to hold the child. That's where the point system comes in, because they're looking for the child to have certain points. Absent a pickup order that directs us to take them to the juvenile court, then that's where the begging and prodding comes along, as far as to detain the child until we can find out what's completely going on.
Thank you. One further, Mr. Chairman. Representative Elverson brought up a question that I had in mind about the males involved in prostitution, particularly underage, and more and more victims of abuse coming to light among the male population. Is it in your mind, or in your analogy, the way you explained the grouping of the males, is it kin to maybe a gang?
No.
That kind of mentality and operation, or
I wouldn't say that, because they're not purposely grouping to commit criminal acts. They're purposely grouping, literally not to be victimized or for protection.
Okay, for protection.
So they're not going out to perpetrate anything.
Thank you so much.
Sergeant, thank you for your time and for your perspective, and most of all for your work. We appreciate it. We appreciate what you've contributed to the conversation. We are going to take a 5-minute break, and I mean a real 5-minute break. With that, when we come back, we're going to suspend consideration of House Bill 582 and respect Representative Davis's time, and I apologize to him for keeping him. We're going to take up House Bill 213, expedite a discussion on that, and then we'll come back to 582. So we'll be back in exactly 5 minutes. Thank you. Representative Davis, thank you for your patience.
Thank you, Mr. Chairman. I bring before you in the committee House Bill 213. As I told you prior to the meeting, I actually authored this bill about 3 years ago as an idea as a parent and a concerned legislator on the increased gang activity that's happening in our communities these days. Listening to some of your testimony earlier about the previous bill gave me some more thought into what's going on right now. But my bill is actually very simple. It goes into the gang statute, and the police and law community are begging for more tools to deal with the gang activity that's happening in our communities today. But as you stated yourself, and I actually wrote it down and I quoted it, gangs are using juveniles for crimes these days. And they are recruiting them right off of the school grounds and in the parking lots. They're getting 5th graders to deal drugs for them, as well as the prostitution and other criminal activity. And the bill is rather simple. It ties the gang statute to the definition of a school safety zone and adds a mandatory 2-year sentence for any gang activity within that school safety zone. And that's in addition to any other penalties required from the courts on whatever crime that they committed. And that's basically what the bill does, Mr. Chairman. And I'd be happy to answer any questions and any discussion. And I know it's a very complicated issue when you're dealing with gang activity and our children. But as a parent of three kids, I can tell you firsthand that our top priority is the safety of our children, and I believe this to be a good measure.
Mr. Sessler.
Thank you, Mr. Chairman. It references. I'm looking on line 48 where you insert the language where a person commits any violation of this code section within a school safety zone. Of this code section, I'm trying to make sure I understand the appropriate references. I think it's a relatively broad reference. Is this going to apply to things like fights and selling of small amounts of drugs? I mean, selling a bag of marijuana in a school zone by a gang. Is that some of the kinds of things you're trying to
Yes, sir. I believe the code section that's referenced there merely defines what a school safety zone is, the 1611-127.1. But the statute that we're in, I believe, is the gang statute for felony criminal activity.
Okay, so we're dealing just with felony criminal activity then?
Yes, sir.
That was really the source of my question. Are we taking would we be taking things that were not felonies and making them felonies by adding 2 years, or are we only dealing with felony actions? Because my concern is you take something like a fight, which is an unsavory action that needs to be punished, or selling drugs, another unsavory action that needs to be punished. And if we're making it a felony by doing this, then that's a whole other conversation. The reference on line 48 of this code section, I was unclear as to what that applied to.
The underlying, as I read it, in the existing law, the underlying penalty for the underlying crime, the gang activity, is not less than 5 and no more than 15 on line 39. And so the proposal is to augment that range of penalty. Is that correct, Mr. Travis? Is that how you read it?
Well, criminal and gang activity is defined in 1615.3, and there actually are some misdemeanor offenses in that. It's unlawful if you look on 11 through 13, criminal gang activity, and then the reference is to 1615.3, and that reference is again on line 19 and line 15. And those offenses, criminal gang activity is conspiring, any of the offenses defined in racketeering, which is there's a huge list in there, stalking, rape, aggravated sodomy, statutory rape, aggravated sexual battery, all of those have misdemeanor components. Escape. Then any offense in Article 4 of Chapter 11 of this code, that's mostly relating to weapons, and there's a lot of misdemeanor weapon offenses. Any offense in 42, 5, 15, 5, 16, 5, 17, 5, 18, and 5, 19, which I don't know off the top of my head.
And to the author, I'm not insensitive to gangs taking knives to school and that kind of thing. Those are things that need to be dealt with. But I'm concerned that as you apply a 2-year additional sentence, in my mind, that kind of treatment applies perhaps as enhancement to a felony. But when we're talking about carrying weapons that's linked to gang activity, fights, drugs, petty drug, more minor drug offenses, I want to be sensitive to that. And I know we're not in the mode of taking a vote today, but I think that's something I would offer to you as a concern in the interim.
Let me just make sure I've got clarity. I mean, I'm violation of this code section, 1615.4.
Right, which means subsections A, B, C, D, E, F, G, and H.
Right.
And then if you read A, it's unlawful to participate in criminal gang activity through the commission of any offense enumerated in 1615.3. So there you
All right, so we just have to go ahead and separate it out then.
keep going back.
Got it.
Down the chain.
Thank you. Ms. Benfield.
Thank you. I have 2 issues. The first is I have a fundamental objection to minimum mandatory sentences. I think it ties the hands of judges and prosecutors. And I like more the flexibility where the judge and the prosecutor can look at the individual case and determine what fits those particular facts best. And I'm looking at the language in subsection 2 where they have may, in addition to any other penalty provided by law, be punished for an additional 10 years. So I'm interested in your thinking behind mandating the 2 years as opposed to, mirroring what's already in the statute in the subsection 2 and giving the judges and the prosecutors the option, if it fits the circumstance of the case, to add 2 more years.
Well, and obviously the fundamental disagreement that you and I might have is the mandatory minimums. My intention is to make a penalty tough on the gang members, and therefore convince them that it's not worth their time and effort to partake in those activities within our school zones, and therefore protecting the kids. And mandatory minimums is something we can debate on every bill that comes through here, but I believe that if we have a gang member going on a school grounds and recruiting a 16 or 17-year-old girl to into prostitution, that they should be penalized, and this is a penalty. There's a carrot and a stick, and sometimes it's heavy and sometimes it's not, and that's just my opinion.
Yeah, I just think that we as a legislature can't judge every single case, and to have a blanket rule that ties the court's hands, I don't think is fair. The other question is actually Representative Abdul Salam's. It's a good one, and that is, how are juveniles? Does this apply to juveniles?
Yes. At least that was the intention of the bill.
Okay, thank you.
Mr. Franklin.
Thank you. I'm assuming that the intent of the bill is that it's for the children.
Yes.
But if we're adding 2 years additional penalty for a criminal street gang activity taking place at a school, why should that be protected any more than my business that's a block away from the school? That now the street gang activity is going to move from the school down to the front of my business. So why? I'm trying to understand why the enhanced penalty for a set location that might then move it to exile it to another location that then causes harm to our business owners.
That's a tough question. It's just like anything else. You have to draw a line somewhere, and it's a balance. And I had to pick an option, and that was the option that I picked, was the 1,000-foot rule. I'll be happy to extend it out if you so wish, but I understand that this is a tough issue, and when you're incarcerating young people for this activity, it's always a difficult time. But at the same time, there's children that aren't involved in these activities that are being subjected to it day in and day out on our school grounds, and that's the intention of the bill. I'm not a lawyer. I don't serve on the judiciary, thank God. But I'm open for other options and ideas. This was an idea that I had, and if the discussion takes us in other directions, I'll be happy to go in other directions with the bill. But I can tell you, I personally have gone out and I've met with the gang task force. I've rode with the gang task force, and they're looking for more tools to combat it, because it's a growing issue within not just in our inner cities, but in our suburbs and farther out.
Thank you.
I think one of the concerns, Representative Davis, that might occur is if you look at the existing law in line 26, really section E, management with regard to a criminal street gang or engage in directly or indirectly or conspire to engage in criminal gang activity. I understand that's existing law. That strikes me as something that you can drive a truck through from making a charge. And so when you take that opinion and then combine that with the additional two beyond that, on top of what is already, 5 to 15? Is that right? And then an additional 10 on E. So you've got 5 to 15, then you've got an additional 10 if they can meet E, correct? And that conspiracy is probably fairly easy to make a case on, and then you're piling 2 on top of that.
Well, and this goes outside of both the subparagraph E as well as A through D, and goes through the entire code section. So it could be on any crime with less of a penalty. It might only have a year penalty on it, and this would require them to serve 2 without parole. And if they even got the 5 years on the additional penalty in subsection 1 there, it does not require them to serve that full term, where the new language would require them to serve the entire 2 years.
Well, they've got the minimum of, under I, they've got the, Mr. Travis, they've got the minimum of 5, correct? and then
It's not served time.
right. Yeah, I mean the sentence. I'm not saying it's served, but I mean it. Okay. Just want to make sure we're clear on exactly what is possible under the sentencing currently. Just
It's the underlying offense, then the street gang activity, then potentially an increase.
okay. Mr. Hatfield.
Thank you, Mr. Chairman. I'll try to take a stab at Representative Franklin's question. As you say, I'm one of the signers on the bill, so I don't speak for Representative Davis, but I'll just give you my take on it. And I'm not a big fan of mandatory minimums either, but until we make a decision as a legislature to, depart from those wholesale, then I feel like there are certain crimes. Well, I'll tell you right now. I think I've said before. I don't like mandatory minimums as a general principle. I don't think that the judge's hands should be tied. But insofar as we are using them in a lot of different areas, I mean, my feeling is there are certain crimes that are pretty serious stuff, and if we're going to deal with them with mandatory minimums on certain crimes, then this criminal gang activity, in my opinion, is one of the things that is more of a serious threat these days than a lot of other types of crimes that you might see young people be involved in. And with regard to the business down the street, this, in my opinion, you've got a situation where you have kids that often attend schools in we don't have in many communities, we don't have neighborhood schools anymore. So a lot of times you have kids attending schools in other areas of the city or county than where they live, and sometimes they're in bad areas. And I think that there are a lot of kids that may attend schools in places and have fears, and their parents have fears about where they're going to school and the type of activities that are going on around those schools. And this is really, I think, aimed at being a protection for the kids who are trying to go to school, get an education, and they're confronted with peers or other kids that are frankly just violent people. And so I don't know that it's really, I don't see it as pushing it down the street. I think it just is saying we're not going to tolerate this on school grounds or within this school zone. And the issue about the sentence time, and the chairman raised the issue of the conspiracy language. Personally, I think if kids are engaging in conspiracy to commit the gang violence or certainly these gang-related crimes on school property, I think it is something that warrants some enhanced punishment. And so I would take the position the punishments that you see in here, and I think I'm correct in saying this, Ms. Travis, that these periods may all be probated. Is that correct? So you might actually have somebody that is actually sentenced to just a long time of probation for these violations. So that's where I get into striking a balance again. Representative Cooper's not in here, but she seems to like to talk about striking a balance, and I think we do have to strike a balance. And that there she is. We're striking a balance. but I think that this bill would strike a balance between concerns about mandatory minimums, concerns about gang-related violence, and the safety of our children when they go to school. And so that's my 2 cents on it. And,
Mr. Sessler.
Thank you, Mr. Chairman. I intend to conclude my remarks, which I know pleases the chairman, just by offering to the author my concern in the making the felony misdemeanor distinction is is that, as you read subsection A, lines 11, 12, and 13 of existing law, any person, and I'm skipping through for purposes of simplicity of grammar, in essence, any person that's associated with a criminal street gang or participates in criminal street gang activity to commit any offense in reference code section, as counsel mentioned, a number of which are misdemeanors. If HB 213 were to pass, would be 2-year felonies. Now we can get into probated felonies or serving time. We can get into mandatory minimum sentences. My concern is when you look at felony convictions in the state, that's where people lose their rights. You lose rights to vote. You lose rights to bear arms. You lose rights to, frankly, pursue meaningful employment, get in the military, enroll in our Board of Regents or technical institutions. In essence, a felony is a life-changing sentence, whether it's probated or not. In essence, any action in a criminal street gang, if this were to pass, would be a life-changing felony conviction. And that, to me, is the crux of this bill. It's not, are you adding 2 years to a 5-year sentence, adding 2 years to a 10-year sentence, but when in essence, I see the crux of this being is you're adding 2 years, and if I'm wrong, I would invite counsel to tell me I'm wrong, but as I read it, you're adding a 2-year, you're taking what could be a misdemeanor gang offense and making it a felony gang offense for really anything that's enumerated in Section 1615.3, which are a series of gang offenses, some of which are felonies, some of which are misdemeanors. And if that's in fact the effect of this, then we just need to understand people involved in criminal street gangs will be felons and will lose their rights, and that is not something to be taken lightly, as I read it, and that's subject to the opinion of counsel.
Well, you actually take the misdemeanor offense that they were involved in. You've already made it a felony in paragraph 1 because you're adding 5 to 15 if they violate subsection A. So what Representative Davis's bill would do would be make it 7 instead of 5. They got the minimum of 5. So you've already, the criminal gang statute itself already increases misdemeanors to felonies if they're involved in the gang.
Okay.
And it also has a very narrow focus only within the school safety zone. Will it be enhanced? So whatever they've already done, they're already convicted of.
Okay. That being the case, I would simply close by asking, is a mandatory minimum of 7 versus a mandatory minimum of 5 the way to empower the Henry County Police to get control of the gangs, or is there some other mechanism that allows them to reach out and touch those gangs and get them under control in a more meaningful way than a tweak to the mandatory minimum sentence?
Well, and I'm sure there's many other tools and that a lot of people are looking at and trying to codify and put into law or just into practice. But again, it goes back to whether or not it's a mandatory minimum, or whether it can be probated, whether it can't. So this would require them to serve a minimum of 2 years for any kind of gang activity within a school safety zone, if that's my understanding of at least that was the intention of the bill.
Ms. Levitas.
If the intent is to have an enhanced penalty, instead of adding years, what about the possibility of just making the time served, the part of the sentence, be time that is not probatable? And instead of adding 2 years, say that X period of time cannot be paroled or cannot be probated. They must serve X period of time.
Well, that might be something that we need to look at here.
Okay. Thanks, Mr. Chairman.
Ms. Abdul Salam.
Thank you so much. Representative Davis, thank you for bringing this bill and attention to the issue. My 13-year-old grandson was recruited in school, at his middle school, and I just wonder how this bill would help in such instances where the kids are recruited in school and seemingly, in his instance, he got into a fight and refused to join, but he was suspended. So I guess I'm trying to figure out, in terms of deterrent and protection on school or within school zones, how does this help in the school?
Well, there would have to be an education period to make sure that we advertise that there's penalties within these zones. I feel bad that you say your nephew?
My grandson.
Your grandson.
But it's a lot of kids. I mean, it's a lot of kids.
And it's happening more and more. And that's why, as I said, I'm not an attorney. I don't know if this is exactly the best way to go at it.
Mm-hmm.
But it was to open up the discussion. Maybe, like Representative Levitt said, that maybe we can take away parole periods or some other avenue of doing it. But I guess we need to get out and advertise that we're not going to tolerate it, and that's basically where we're at. So we're giving, not only are we fighting it through police activity, but we're fighting it through legislative activity and telling them that we are not going to accept this behavior and we're going to fight it, and if you do it, we're going to penalize you. And that's what the whole crux of the bill is to try to add an additional penalty so we can put out into the schools that if you get in a gang and you're fighting in the parking lot or you're doing any of these initiation activities in the parking lot or in school grounds or at the football game, that you're going to be penalized and it's going to be severe.
Mm-hmm.
And you're going to lose 2 years of your life, and as Representative Setzler says, you're going to lose some of your constitutional rights.
I agree. I think the only bad thing about it, though, is that in many of the instances, nobody's arrested, so it doesn't deter. And on the other hand, the people that are offending aren't going to be aware of these penalties. They know that it's illegal, so 2 additional years won't make a difference.
Ms. Benfield.
Just a quick comment to the suggestion about the parole or probation. If the sentence is structured in such, I'd like to make sure that any sentence was structured in a way that there is parole or probation. You could still have a certain part that would have to be served, but I don't like the minimum mandatories at all. But I just want to make sure there's a real valid function to parole and probation, as Ms. Representative Everson knows. It's an opportunity for the state to continue to monitor that person and see how they're doing as they transition from being incarcerated to the outside. So that would be my one suggestion if you're looking at some different options for this, that parole and probation does serve a valuable function. So you don't want to do away with that option for judges. That's it.
Representative Davis, thank you.
Thank you so much.
Appreciate your presentation. Absolutely. Sorry for your wait. Sandy Michaels on behalf of the Georgia Association of Criminal Defense Lawyers.
Thank you, Mr. Chairman. But just very briefly, I was going to start out with what I'd respectfully ask the committee to do. I think there's been a lot of questions raised on this legislation, and one of the things the Georgia Association of Criminal Defense Lawyers, I don't want to speak for Mr. Malone, but the DAs have also been opposed to mandatory minimums. One reason, a problem in the mandatory minimums of this day and age, of course, is the cost of mandatory imprisonment. That's a huge, huge issue right now, not only under our indigent defense system, but certainly under our Department of Corrections system. Second issue is very similar to the bill that we've been listening about the last couple of years. Hours. Sorry, guys, I didn't mean that. But one of the concerns has been, and
it just feels that way.
I know. I apologize. I didn't mean it that way. But I was talking about how many years we've been working on the gang bill, the Criminal Defense Lawyers Association, from a number of concerns. But one of the issues is that many young men join gangs for a variety of reasons: peer pressure, certain lack of home. I think, as the officer said, you don't meet people that join gangs that come generally from a very strong, tight family with good economic resources. That usually doesn't happen. For those of you, and I don't think there's very many in the room, but I can say that I have represented a large number of gang members. Many of them are young people that really wish for a second chance in life. And being labeled a felon, as Representative Setzler said, sort of closes that door down for them. Recruits become recruiters. For a variety of reasons, many of the same reasons that unfortunately apply to young women that become prostitutes. It's just a psychological problem. What I would suggest is one of the issues I think Representative Davis might have been concerned about maybe is not young people becoming involved in gang, but the older people that are recruiting gang members, because under this statute you would also include that nebulous stage that Ms. Hart and Ms. Espy talked about, the 17-year-olds. Now they'll be serving mandatory 2-year terms under this proposed language. So I thought one maybe change would be to make it more applicable to the older person as opposed to the young man who's sort of on the cusp of still being a teenager but not quite an adult. I would like to bring the committee's attention on page 2, line 33. This was, and I think this bill's been around for 10 years. I know we've had issues since the day it was suggested. But it should be unlawful for any person to communicate directly or indirectly with another any threat of injury to person or property. And certainly subsection H is included in the mandatory time. That could be as simple as someone saying, you know what, if you don't join this gang, if you don't do it, we're going to get your family, or we're going to mess up your house or your car or whatever. Saying these things can happen. Is it a crime? Sure, it's a crime, but if it's someone communicating indirectly to another person, do you know, Joe, head of the gang, told me that if you don't do this, I mean, that's a scenario that's completely within the realm of possibility under this language. So what I was going to respectfully request that we work with Representative Davis on perhaps some language that would encompass some of the concerns of the legislators that have raised them today. Also, I think there's other groups that might like to be involved in addressing some of the issues, and perhaps maybe be in a subcommittee to look at some language that might help it out a little bit.
Any questions from Ms. Michaels?
Thank you.
Seeing none, thank you. Ms. Jenny Hodges had signed up to speak on House Bill 213.
Thanks very much. I appreciate any efforts to protect our children, and I have a couple questions about this bill in regard to whether or not it's unconstitutional to not offer equal protection under the law. It kind of is interesting how we elevate school areas for greater protection than the rest of the citizenry. I think, like Representative Franklin was indicating, our local business owners chopped liver. I mean, don't they deserve the same amount of protection? I think if we're going to crack down on gang activity, that's a great idea. Is 2 years a sufficient way of going about it? And what does that cost the taxpayers? If we're talking about gang activity within our schools, one of the things we need to be looking at is the fact that we herd thousands of children together. Talk about bad company corrupting good morals. I have 6 children, and I've been accused when I was full-time homeschooling of not letting them socialize. And I said, yeah, that's why I homeschool. I don't want them to socialize. You got that right. And also what we're feeding them, the high fructose corn syrup, the color additives, the genetically modified food, leads to criminal behavior. They're not paying attention. Study after study has shown across the country schools that look at what we're feeding our children, and we claim that we can't afford to contract with local sustainable agriculture farmers and change what we're feeding the children to stop this criminal behavior. I think that's ridiculous. We need to have small local schoolhouses. Think how much money we would save not busing them all over the place to congregate in thousands, having 40 in the community in one schoolhouse where you have community leaders getting involved. In West End, where I go to church, our pastor is very involved with the local children. And if they get in trouble with the law, they will actually fulfill their suspension time in the community garden. And they have to be involved, and they have to work hard for 8 to 10 hours a day in the community garden under Pastor Bright, and their souls are getting shepherded. They're tired. A tired child is going to be good because he's going to go home and take a nap. So I think if we want to really address the criminal activity in our school systems, 2 years mandatory sentencing is not how we need to go about it. We need to go about it with the food. We need to go about it with the busing thousands of them together, local small schoolhouses, and engaging the community leaders, the community pastors, and the community mamas who let them have it and make them behave and make them learn. Thank you.
Thank you, Ms. Hodges. Representative Davis, where are you? Just thank you. That's all the witnesses that we have, and we'll obviously work with you on language going forward. Thank you. We'll go ahead and continue our discussion, I should say, of House Bill 582. Let me ask Melissa Carter with the Office of the Child Advocate to come forward. Ms. Carter, welcome. Thank you for being here. I'm going to ask you sheepishly to please limit your comments if you would. We've been here a while. We'll be here a little while longer. And we'll march on from there. Thank you.
No, I will be happy to be brief. It's nice to see all of you again. And I'm pleased to be here before you on this bill. I would like to start with kind of what I think is the luxury of the knowledge we have about this issue. This state has been aggressive in our approach to combat commercial sexual exploitation of children. Excuse me, we refer to that as CSEC, so that was stumbling through the acronym. And we know who these kids are. And it's been a silent and invisible problem for a very long time, but we do know who these kids are. And they are, as has been eloquently described to you, children who have been severely and repeatedly abused, either at home before they came to the streets, certainly once they come to the streets, and they are certainly acting under force. And those are characterizations that are reserved in our discussions around the law for victims. And we certainly appreciate it from that perspective at the Office of the Child Advocate, and believe that these victims need to be dealt with from a service mentality. And as part of that, our office, particularly Judge Rawlings, has been involved with the task force that's been created through the Governor's Office of Children and Families and is being coordinated by that office. And I wanted to highlight a couple of things that Chairman Willard did present in his opening, but just wanted to come back and emphasize for you, which is that the General Assembly appropriated close to $1 million for services and development of an infrastructure to treat these youth. And part of the task force agenda is to create that infrastructure. And partly they're looking at additional funding streams and how to braid particularly specific federal funding streams together in order to create a package of services specifically targeted to the unique needs of this population. And then, as I mentioned, they'll also be going towards the further development of community resources, including facilities, treatment bed space, et cetera. And so again, I think that we're reacting to this as a state in a way that we can all be proud of. We support this bill as one first step. It certainly has, it's not a panacea, and you've identified many of the issues and the limitations through your discussions here. But we do support this bill and hope that we can count on your leadership as, again, one more step toward being able to funnel these youth from a criminal mentality, when they are in fact victims, more toward a service modality, which is what we're all working very diligently to create and to enhance it for our state.
Just a quick comment. The discussion goes forward, but my sense is that we're, especially from the comments of Sergeant Britton of the APD, that some of the tools that they need, their ability to act with regard to a juvenile of a certain age at a certain situation under certain conditions, engaging in perhaps certain conduct. I think from a practical standpoint, as you know, we talk about a lot here, translating words on paper to the practical realities of operational implementation when it comes to law enforcement, and especially in an area like that. I think it's going to be important if we do go forward for in the context of the DA, of the language that the Fulton DA brought us, and some of the polishing that's got to do there for Judge Rawlings in your office, especially given his experience with the committee and statewide, to make sure that if we do go forward on expanding that ability of law enforcement to get those individuals off the street, giving them the tools that they need, it'll be really important for there to be some close coordination on, okay, how is this going to translate, using his background as a juvenile court judge, and of course bringing in law enforcement and the DAs as well, while we perhaps stop short of that blanket presumption on the 18 or under. I'm not saying that's what we will or won't do. I'm saying that that's an issue,
sure. And
that I think from a practical standpoint, we look at what does law enforcement need to help these kids get off the street quicker and in a more efficient manner.
And I've not seen the amendment, but from the discussion, I sort of feel
Sure.
like I understand it. I think that it's a good direction to sort of codify what would be sort of a protocol for how law enforcement would redirect these youth to services and to give them the additional tools that they need. And I would be remiss for not mentioning that part of the effort of this task force, the CSEC task force, is to conduct trainings with law enforcement. And also in this service modality that they're creating is this continuum of care, which is, you know, the model that they're pursuing with KidsNet. You might have heard that lauded, and the mental health arena. So to use that framework to develop a continuum of coordinated services for this group of children as well.
Mr. Collins.
Thank you, Mr. Chairman. I want to continue. You said you've not seen this proposed amendment from Fulton County, but you've listened to it and you said it was a good idea. speaking with Judge Rollins, who we've dealt with on many other things outside this committee as well, my concern lies, and it was just at the time just not needed to get into, but in a division with DFACS and with other agencies right now which are already burdened to a breaking point, we're adding in another issue here that and it's it's within 48 hours. There's no discretionary here. It's if you're taking them to a place 48 hours. With involved in the task force and others, what has been the reaction from, or has there been discussion from the Family and Children Services concerning cost, manpower, other issues? I'm afraid we're putting we've had an amendment dropped by a non-member, but I mean, an amendment that's been put out here to talk about that doesn't look at how that, in essence, says this is a great plan, but in the end it will lead to frustration because they're not able to fulfill this idea.
Let me just make sure there's clarity. You're talking about the increased cost on the mandated assessment within the next period of time, right? As per the amendment language, right?
As per my question.
Okay. And that was offered by Mr. Willard.
Okay, so
he said he endorsed it, but
I have to say I might not be clear now on the question. Are you asking me to speak to the burden on DFACS for dealing with this population? I'm not sure I understood it with reference to the amendment.
I'm not sure, to be honest. After Vice Chairman may have a different idea than what I had.
Okay.
Well,
I can try to speak to that.
Right. This is on the increase, the 48 hours, and the cost related to the assessment as per the 48 hours.
I thought that's what.
Correct.
I apologize. I thought that's what I asked.
Well, I'm just making sure that we were clear on that.
Okay, and it might just because I didn't have the language in front of me that I wasn't keeping up with your question. I apologize. This issue about a child safety or assessment within 48 hours, which goes to your question, the department already has timeframes for responding to reports of abuse or neglect. And so if this now, a report would come in on one of these exploited children to the department per this language, they already have timeframes for response time. And so this is just now specifying within 48 hours that response has to be made. I can't speak for them in terms of whether they'd prefer to have more discretion to assign that timeline rather than have it prescribed here in law, but this would map to their existing practices for investigating a report.
But we also already know as well from previous discussions that I've had with them that they're again burdened at the point now of trying to do this at 48 hours, and we're simply adding another at this point adding another line into this item. And I'm just again, undoubtedly my questions aren't clear, so I'll stop here. But I'm just concerned that not that it's a bad idea, but it's like all logistical operations. You've got to see what your resources are and how you do it, and you're just adding on top of an already very burdened system that has been shown many times through good people just falling through the cracks.
Yeah, there's no question that our DFAC system is overwhelmed, and quite frankly, our entire juvenile court system, if you would expand that to include detention facilities under DJJ, et cetera, you all hear those debates. There's no question. I do think, though, and I also have to be clear that I can't speak on behalf of the department, but I do think that they understand the abuse dynamic that's going on here, and provided with the right tools and supports and services in the community such that they have a place and a way to respond, that they would be supportive of that. And the development of those services and that community capacity, the bed space, the actual therapeutic environments and interventions for these kids, that's really where the focus has been, so that we have a response. And the issue has been what to do with these children. Nobody seems to have the right avenue for handling these children and their particular needs. And so, again, developing that at the community level has been the emphasis, and I think that the department would be a supportive partner in this, provided that they had those resources available to them.
Thank you.
Mr. Sessler.
Just to take off on Representative Collins' concern, I would encourage you to, as an agency, consider rather than a government solution, perhaps a leadership move. So often we as legislators are given options. Sometimes there's a government solution, and sometimes there's just a leadership solution. And I would ask you to consider a leadership solution where these young women, these young people are brought in, and in the hands of law enforcement, there is an assessment, sort of a triage there, but that there be an ask. And the ask not necessarily be of the Appropriations Committee, but the ask be of the state of Georgia, the foundation community, the faith community, not through government-funded programs. But I don't know that anyone's come to, and I'll use my personal church, it could be a synagogue, it could be any faith community. No one has come to our church and said, we want you to be on standby to take a young female prostitute who's been taken up by the Cobb County or Fulton County Police and care for them for a period of time. I think that kind of ask needs to be made, and whether it's to a foundation, whether it's to faith community, I think I would challenge your organization to consider a leadership move rather than a government move, because I think refine what the ask would be. But I think we've got a leadership in the state that would be open to that. I think it's uncomfortable for us. Well, what happens if they mistreat? What happens if they don't treat like we would in an institutional bed? But I think those are the kinds of things we need to consider, and I would challenge you personally to do that, because I think this issue resonates across the spectrum of people in Georgia, across political, demographic boundaries, but I think there needs to be an ask other than of the Appropriations Committee.
Understood, and I do think that's a fair point, and in both to hold true to my reserved comments, but also I know that lots of folks in the audience, and among your list of witnesses who will testify, there are people who can speak to that issue and do so with great depth of detail, both in terms of the service array and what you get with a treatment bed, and those really are unique targeted services for the unique problems of this population. Part of, just to speak to your suggestion that these children can be housed in a family, quite frankly, many of them can't. This is a high degree of reactive trauma, and those needs can easily expand far beyond the competencies of most well-meaning and even trained adults in the community. But I will reserve that for some of the folks who will be speaking soon. Likewise, and I hope Patricia's going to speak, but the Interfaith Children's Movement of Metro Atlanta, which is a network of faith-based organizations who have engaged on this issue, are represented here today as well, can speak specifically to your request about the information around the faith-based community being involved.
Ms. Carter, thank you.
Thank you.
We appreciate your joining us today. Let me ask Elizabeth Apley with the Women's Policy Group.
Mr. Chairman,
Yep.
I go last? I know Kirsten Widener from the Barton Clinic is here. Mindy Benjamin from Voice of Georgia's Children. Reverend Scott Weimer was here.
Okay.
Testified.
Sure. That's fine. Ms. Widener with the Barton Clinic.
Prepared remarks, but I think rather than take the committee's time on issues that you've probably already heard about, I'd like to respond to some specific concerns that I've heard raised through the course of the day. One of the questions that was just raised, I believe it was Representative Collins, was related to the additional burden on DFACS. We have already put this population in DFACS's care with the change that we made through SB 69, which this committee heard and approved in the last legislative session. They are actively engaged and at the table with us and other community partners trying to develop their protocols and solutions for assisting this population, and they're very committed to that. So I don't know, I can't speak to the specifics of the 48-hour requirement. I don't believe they've seen that language, but I know that in general they now know that this is a population for which they're responsible, and so they are engaged in that issue. The other thing that I believe that the DA's language did was allow that assessment to be done by other organizations in the community. So that sort of speaks to the comment made over here about engaging people other than state actors receiving state appropriations. I believe it allows a range of community organizations to participate in that risk assessment, but then report their findings to DFACS to figure out whether or not a deprivation proceeding should be initiated. Coming back to questions from earlier about whether or not deprivation is sufficient to handle this issue, most of you who have interacted a lot with the juvenile code will remember that deprivation is focused on problems within the family unit, and not all of these kids are in situations where the family is the cause or even playing a role in the problem. They've been kidnapped, they have been maybe they've run away voluntarily and then ended up in these situations, but it isn't always a family problem that's at risk, and in those situations the deprivation code sections don't necessarily apply to these children, and so that's why other avenues for helping the children get the assistance and services that they need are important. Coming back to Representative Franklin's concern about the coercion defense and whether or not that's sufficient. The coercion defense is very limited to great bodily harm or threat of death, and it's also, these are kids that are experiencing much subtler forms of coercion in general. Not always a direct threat of death. They might be getting beaten up, which might not rise to a court standard of great bodily harm, but is still significant enough a threat for the child to keep them in the activity. Additionally, some of them are threatened by having their identifying documents stolen or other things that wouldn't fall under the coercion defense as it's currently written. And so that's why that defense isn't always effective. The other thing I wanted to just point out is this piece of legislation is part of a larger puzzle of what the advocacy community and this legislature has been working on over a number of years. So back in 2000 and 2001, we did increase the penalties for those who exploit children, made those a felony, as Ms. Travis pointed out earlier for us. We have created forfeiture of vehicles and profits used in these things. So on the punishment of the offender side, we've done a really good job as a state in addressing what needs to be done to appropriately affect it from a criminal justice end for the people who are exploiting children. This last legislative session, we recognized these children as abused children and developed a new mechanism for identifying them through the mandatory reporting system. And so that's another piece of the puzzle. This piece really is just intended to eliminate a current conflict of law. We have a situation where the law defines the same child as both an offender and a victim for the exact same activity. And that's really what this what this bill is intending to get at, is that conflict of law between what is the status of this child. Because right now, a police officer looking at the law will see that the child has committed an offense. They may also see that the child's a victim, but that individual officer on the street or that individual DA has to make that decision between two conflicting statutes. And we believe that the law should be clear and it should speak with a unified voice as to the status of these children and treat them uniformly as victims. We talked a little bit earlier about creating a universal presumption and the danger of that, because there might be some children who don't fit the mold. We have a universal presumption in the law now, and that is that they're all committing an offense when we know that probably most of them are victims. And so the question is, which way do we want the presumption to tip? Do we want it to cover the bulk of the people who are at risk, or do we want it to function so that we can prosecute a very small minority that we don't see as a regular function of practice?
Well, don't we want to go ahead and treat these on a case, to your point exactly, do we not want to go ahead and treat them on a case-by-case basis, but give law enforcement the tools that they need in order to make that credible that analysis and to make it a credible one?
The problem really is that what we know from the centers that deal with this, the Regional Assessment Center, which was established about a year ago by this General Assembly, Mr. Chairman, has found that it takes about 30 days to get a child to disclose enough information to be able to make that credible assessment. That's not something law enforcement's going to be able to do on the street. Even with the appropriate tools, what you need to do is send that child to a therapeutic center where they have the ability to make those disclosures, and arrest is not the proper mechanism for getting them to that facility. And so that's really what we're trying to combat.
And that's fine. And then you take the time and the resources necessary, again, to make that analysis and to draw that reasonable conclusion from that which they really need, that type of interaction or therapy, whatever it may be. No problem with that. The clock is ticking, but so what? I mean, you make a determination based on those protocols, but a determination is made. My sense of it from the conversation that I've heard, that in the vast majority of cases, they will be a victim. But shouldn't we go through a due diligence exercise, again, giving law enforcement, giving defects or whoever the tools necessary to make that analysis, and then make a decision as opposed to starting off with a presumption?
I'm certainly supportive of having a full process that gives everyone the tools they need to make that determination. I do think there is a subpopulation of these children who will never be capable of consenting to these crimes, and that's the population under 16. They can't consent to have sex. They can't consent to dangerous employment. There's just no situation in which those children should ever be considered to have committed this crime.
I don't think anyone disagreed with that in the Q&A previously. I think really where the crux of the focus of the discussion was on that 17, that in between gray area that Judge Hart brought up. And that's really where I'm focusing on, just speaking for myself, of course. But I think that's where we're really looking in terms of what is it law enforcement needs in order to make sure that these victims, and I'm sure that they are victims, are treated as such, stopping short of the blanket presumption. That just may be a policy call. Let me, no, Mr. Knox is going to wave. Mr. Franklin.
Thank you. If you believe that the coercion code section 16.326 isn't quite tight enough, would you be more willing to amend that section to make sure that that these children who are being coerced with something that you don't believe meets the strict definition here, rather than saying that, as Chairman Willard is proposing, that a 16 or 17-year-old child can voluntarily now, with the passage of his proposition, become a prostitute without any criminal offense? Wouldn't changing the coercion section be a better way to go?
Well, I certainly think that modifying the coercion section could have benefits. We would need to engage with the broader legal community before we made any assumptions about that. We'd like to talk with the DAs and the defense attorneys to see their feelings on whether that would have impact for the other crimes that statute applies to, because obviously it doesn't just apply in cases of commercial sexual exploitation. But I do think that that's an avenue that could be pursued. One other option.
Could you look at that, between now and January, and try to come up with something like that? Because that might be the solution, where we don't have this blanket exclusion that Chairman Willard is proposing, allowing those who today wouldn't even dream of entering a life of prostitution because it's a criminal act, who would then say, the state of Georgia has now said it's no longer a crime for me to do this. I think I'll start giving it a try. So I would urge you to try to look at how to clean up 16.326 to actually do the intent that I'm hearing for this bill, and that's to not treat these children as victims, which I think that would do, rather than Chairman Willard's proposition.
And we're certainly happy to look into that. Another option this committee has, instead of getting rid of the presumption, is to change the age of the presumption to an age that we all agree on, which I think is 16. And so that's another potential option. If we know the child can't commit the crime below that age, that would be a possible alternative that would still protect. We know the majority of these children are between 13 and 15 years of age. So that would protect the majority of children as an alternative.
That's an interesting possibility. Mrs. Cooper.
I would just like to say, so that it would be on the record, that over and over again, Representative Franklin has said that Representative Willard is proposing in a bill that we have free prostitution. That's your interpretation of the bill, and certainly not what he is intending in the bill. And this session is supposed to be a discussion, and this is only a proposal, but certainly not what Representative Willard is willingly proposing that occur, and it's your interpretation of it.
I mean, I don't want to get into. I would ask committee members not to get into a back and forth individually about people's positions. As always, members of the committee, as well as witnesses, are free to express themselves any way they want. Whether or not someone agrees or disagrees with them is their privilege as well. All we do have to go on are words on paper. By the same token, I'm the first one to say that when bills come in and words on paper, there's a presumption that they're going to change. There's a presumption that they're a starting point. There's a presumption that, yes, this is what it is, and certainly can be characterized in various and sundry ways. We all accept that, including Chairman Willard, and I don't think he'll be angry for me saying that. By the same token, we do have a process which begins right here, right now, on looking at an issue and arriving at a common sense, potentially arriving at a common sense middle ground on it if one exists, and this is part of the process of going to it. But in terms of characterizing a piece of legislation and what people want it to say, or intent versus what it says, I don't think it's constructive for us to get into a back and forth personally on that. I just think people have very deeply held positions on it, as they do in many of the issues that we tackle here. Boy, that's the understatement of the year, isn't it? but let's just let's keep our characterizations, I think, to limited to our own opinions. I want to thank you.
Mr. Chairman,
Yes,
I
ma'am.
have my intern. We're
Yes.
a teaching institution
Okay.
at Emory, and
Good.
she had prepared a response to a specific concern that had been raised to us by the DA's association. Could she have just a moment to speak
Yeah,
briefly
if you could
about
just
that?
keep it brief, if you'd introduce yourself.
I'm Salmi Kantamnani. I'm from the George Washington Law School in D.C.
Welcome.
Thank you. But I'm originally from Atlanta.
Good.
It was brought to our attention by the Prosecuting Attorneys Council that there is a concern that by changing the definition of prostitution through HB 582, that it could potentially have a negative impact on other sections of the Georgia Code that cross-reference Section 1669, which is what this bill is amending. Excuse me. Their primary concern is that while the amendment will prevent the prosecution of children under the age of 18 who are sexually exploited through prostitution, it may inadvertently prevent prosecution of those who actually exploit children, which has been brought up in the discussion today. We have reviewed the various sections that rely on the definition of prostitution that's set forth in Section 1669, and we agree with the Prosecuting Attorneys Council that the bill could be misinterpreted to limit the effectiveness of some of the other code sections which we have reviewed. As a result, we worked with the Women's Policy Group to draft an additional line at the end of the Section 1 of the bill, which we believe will avoid any potential misinterpretations. Specifically, we would ask the committee to consider inserting at the end of Section 1, for the purposes of all other code sections referring to prostitution, the act of prostitution may be committed by a person under the age of 18, but the minor shall not be considered to have committed an offense. As demonstrated by Kirsten's testimony, the Barton Clinic strongly believes that children should not be prosecuted for their own exploitation, and we support HB 582.
Thank you. Well, whenever we have a statute or a proposal such as this, it inevitably touches on other statutes. There are inevitable conflicts that have to be worked out, and the cross-reference exercise that I know Ms. Travis enjoys just as much as I do. And but we appreciate your pointing those out, and at the appropriate time we'll hash through them. Mr. Collins.
Just a quick question: was there any case law to back up the additional language there that would inherently tighten that up to where it would not affect, or is that just simply and it's a good assumption, it's a good blush because the question's been raised many times by the committee already. I mean, would that language fix it, or is there still another possibility of issue here?
We would welcome Ms. Travis's feedback and assistance in tightening it up. There isn't any specific case law that we drew that from.
Okay, because it's just a characterization of one area, and I was just curious about it. Thank you.
We thank you very much. Just as a point of reference, we are going to conclude at no later than 1 p.m., so just for planning purposes. Reverend Scott Weimer of the North Avenue Presbyterian Church. Okay. Ms. Pamela Perkins with the Interfaith Children's Movement. Welcome. That doesn't mean we have to go till 1 o'clock. It's just that we're not going any later than 1.
Point well taken.
Thank you.
Thank you, Mr. Chairman. And
Just trying to keep the wheels on the track.
Thank you. And first, I'd like to make a personal apology to the chairman. I was in conversation when you called the meeting to order. I was unaware.
No, please don't.
So I want to
No, please don't.
apologize for
No,
that.
please don't.
But
Thank
I'm
you.
Pamela Perkins from the Interfaith Children's Movement, and we are here in support of HB 582, the bill under discussion. And the Interfaith Children's Movement has been heavily involved in trying to eradicate child sexual exploitation, along with the many other organizations gathered here today. On a personal note, to Representative Settler's point about whether or not faith communities are involved, I attend a faith community that served children who had been sexually exploited. And so from a first-hand basis, I know that they need the treatment that is available to them at places like the Regional Assessment Center. I know the limitations of having a faith community take primary control or supervision of children who are in need of mental care, physical care, The spiritual care, yes, absolutely. But the faith community alone is not the sole answer. We need all partners. And so that's why the Interfaith Children's Movement is so very involved in trying to ensure that we have not only the Regional Assessment Center that is in place, but that there are others that are built across the state. There are children who, as has been stated, who are as young as 6 years old, who are sexually exploited. And until we begin to deal with this on a holistic basis, we will continue to have this problem thrive within the state of Georgia. And so we ask you, as legislators for this state, to please support Bill 582, and we would be more than happy to come speak with you and your faith community. I look forward to greeting you after this session. Thank you. Thank you.
Number one, thank you, and most of all, thank you for the work that you're doing. Work like that is never stops, never gets the recognition that it should. But I'll bet you sleep pretty well at night, knowing what you do.
It depends on what kind of day we've had.
I hear you. We appreciate your faith and your willingness to step out when others are not, on behalf of these kids. Let me ask you a little question. In general, what is the ages of the kids that you work with?
We have.
What do you see?
We've been actually working with teenagers,
Mm-hmm.
so it would be from 13 to 17 years old,
Mm-hmm.
and they were brought to us via a group home,
Mm-hmm.
and so we've actually engaged with the psychologist there at that particular group home and tried to get ourselves up to speed on what to look for. They couldn't be left alone, and because we had other children also in the outreach program, you had to really be careful in how in the socialization process, because some of the children had not been socialized in an environment where they would have healthy attitudes, healthy interactions.
When you see the kids that you see, do you see as a practical reality when you're on the rescue end of things? So what the damage has been done, and now you're trying to clean up the damage. Do you see from your experience what the kids tell you? Is part of the pimps or whatever you call them, the people who engage in this type of trafficking, is one of their main strategies to drug abuse is to introduce drugs to the child and introduce a dependency there that will help them gain control of the child during the nightmare, I'll call it, and you see that after the fact. How much of that is how much of that interplays?
Yes, and actually a myriad of intimidations and control mechanisms, as
Mm-hmm.
have been stated. The verbal threats, the beatings, the drugs, definitely also, and it's not just strangers. They are parents. We had children whose parents had pimped them, so it's not the movies, where you see the stereotypical pimp with a big hat on and he's, driving around in a fur coat. It's the uncle, it's the boyfriend or the father's girlfriend or a brother. It can be, the pimp can be anyone within that child's life, and which makes it that much more difficult because they develop a protectiveness about their abuser. And so it's really hard for the children then to open up. And they become because they're dependent on them. And so it's more than a 30 days, a 30-day program, and you're all cured. It's a lifetime that has to be restored.
Mm-hmm.
And that's why this
It sounds
is
like a
so
thorough
important.
brainwashing occurs.
It's a thorough brainwashing, and it endures.
Thank you for taking the time to be here.
Thank you, Mr. Chairman.
It's an eye-opener.
Thank you.
Thank you. Ms. Stephanie Davis? Okay. Ms. Appley, you're up. You asked to go last. You're last.
Can you give Mindy 1 second for Voices for Georgia's Children?
Oh, sure. 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 That's no problem.
Good afternoon, Mr. Chairman. I'm Mindy Benderman from Voices for Georgia's Children, and I really wanted to thank you and the rest of the committee for giving this topic so much time 6 months, as you've said, and so much time today, because this is, as Representative Setzler said, this is an issue that we've worked on together that deals across party lines, across, all across Georgia. People are concerned about, frankly, what kind of community, what kind of state we have that, and how it treats our kids, and how to protect our kids from being victims of child sexual exploitation. We support this bill. We believe that it's an important step, as Ms. Widener said, a part of the puzzle of the different pieces that we've put in place. We do believe that, and we'd like to look more closely at the Fulton County DA, at the Fulton County's DA's amendment. We believe that there is some of it might be training, but there is some merit to look at how we treat these children differently in a more of a deprivation framework than a delinquency framework. So we would like to look at that farther, and so I again appreciate the time that you've put, and just want to express again our support on this bill, and we look forward to working with all of you. So thank you.
Thank you. I see no questions.
Mr. Chairman, members of the committee, my name is Elizabeth Apley, and I do thank you very much for holding this hearing, for your time and attention, and thank you to Chairman Willard for bringing this bill before you. Very briefly, we see this problem, having worked on it for a number of years, as one not of entrepreneurial girls who are trying to make extra money, but of the symptom of a society where these girls, these minors, 13, 14, 15-year-olds, 16 and 17-year-old girls, are being preyed upon because of their youth and vulnerability, but also, quite frankly, because in this sexual market of buying sex, youth is more desired. And that is absolutely something that is pursued and sought out, and they become victimized not only because they're vulnerable, but because they're, the fact that they're not adults is something that is sought out in this sexual market. So that's a tragedy. We also know that there's not a bright line that is easily determinable. Patricia just mentioned that it takes more than 30 days before they start to sort out how this happened and what it means for these people. So there's not a bright line between an entrepreneur and someone who is being sexually exploited. The testimony has been uniform that the vast majority of these girls are sexually exploited by adults who are most often, twice their age or more. So what this bill does is address the fact that as the system currently operates, criminalizing prostitution is not working to get these girls into the treatment that they need in order to recover. We know that the harm to them of going into the criminal justice system means that they are bailed out by their pimps within 24 hours. They continue to avoid and try to elude police officers. They're not ending up being brought into the system, treated, and restored to their communities. And so what we're trying to do with this bill is look at the cost-benefit analysis, and I thought that Ms. Widener made that presumption argument very powerfully. But we feel that if a 16-year-old or a 17-year-old, and certainly a child younger than that, is engaged in prostitution, whether you characterize her as being exploited or an entrepreneur, that's something that has gone terribly, terribly wrong for that girl. Terribly wrong for that girl. And we see her as a victim who needs treatment just as much as someone who's been preyed upon by a pimp. And that there is no benefit to the state of Georgia by criminalizing her and putting her in jail. So what we have proposed with this legislation is for the state of Georgia to recognize that because of their minority, that we should be treating these children as victims and not as criminals. That the system is currently operating does not serve their interests or the interests of the state of Georgia. The amendment process that the district attorney has proposed gives the police more options, allows them to pick up these girls, bring them to a regional assessment center, bring them to the juvenile court for a deprivation analysis with a lower standard than probable cause. So because the police officer is saying it's very hard to pick them up as the law is now. The issue of defects is a very compelling one, and I think Melissa Carter answered the question very well. But the real question when we're talking about these children is either pay now or pay later. I mean, they are not going to get themselves out of this system. Putting them into the criminal justice system is too expensive. Putting them into a life of crime and drugs and abuse where they're recruiting other girls is too expensive for the state of Georgia. So we're trying to bring defects in at the earliest possible point to act preventively for these girls. A couple of questions that had also been raised by the prosecutors earlier in this process is, will we be able to compel her testimony if we don't have the threat of criminal charges? And so the Paul Howard's amendment proposes that for those cases where there is a pimp who can be prosecuted, where there is an uncooperative witness, the DA would have the option of characterizing that witness as a material witness and utilizing that strategy. Finally, we want to be sure that the bill as drafted protects the ability of the state to prosecute those who are preying on the minors, and we want to be sure that that reconciling occurs. There are other precedents in the law where even if the person who is engaged for criminal solicitation cannot themselves be criminally prosecuted, the person soliciting can. So we have that precedent in the law, and that's the kind of thing we'd like to follow up with. We, again, are very grateful for your time and attention. There's a lot of data about how this is operating and the tragedy that this is for the state. It's not an isolated instance, and that's why we appreciate your taking the time to look at the issue.
Mr. Setzler.
Mr. Chairman, appreciate all the effort and the folks that you've helped bring together here to bring testimony today. And as we go through this, I'll have a number of questions. I'm trying to formulate 3 or 4 questions, so I'll try to limit it to just 1 or 2.
We all know better than that. You just can't.
You're
just not going to be able to pull that
try,
over.
Mr. Chairman.
Pull that out.
I'm trying to unpack for myself the difference between and I thought the point you brought up about a young lady that's brought in for a criminal charge and is bailed out by her pimp and she's back on the street within 24 hours, vice a person that's treated more as a deprived youth, right. And because the deprivation comes from their parents or their guardian, aren't then turned back to their parents and guardian. They then are kind of shepherded over into the hands and protections of the state, because the parents, the guardians, are really the ones that are the source of the deprivation. I mean, I kind of see a difference there. Mm-hmm. Are you? Am I hearing you advocate that your goal is to have these young people turned over into a defects channel because the criminal channel always leads to, if the bail's paid, they're back on the street, and that the cycle continues?
Right. And yes, and even if they're sent to juvenile court, they're treated as juvenile delinquents and detained. And as has been pointed out, they are not in a situation where being in a youth detention center is going to help them or resolve the issue. They need a specialized psychological, medical array of services to be restored. That with the criminal law as it is now, we are taking a fork in the road that sends them, whether it's as juvenile delinquents or as criminals in the adult court, that doesn't get them into treatment and doesn't effectively get them off the street.
I don't know if any states, we talked about 2 states that are looking to implement this. New York was one, and do you know the other state?
Michigan did.
Has this been implemented yet in those states?
Yeah, in Michigan, they passed a law criminalizing above the age of 16, so they decriminalized below the age of 16. And New York passed a safe harbor law that's somewhat different than this because they have a different juvenile justice system, but it also creates a safe harbor for juveniles against criminal prosecution for prostitution.
And my question is this, and again, something I've not really unpacked in my own mind is, if you've got a 15-year-old young woman on the street corner who is soliciting sex for pay, but she's not committing a crime. But the person that comes up to solicit the sex, the other criminal in this sort of criminal triad here, in between the pimp and the prostitute and then the John. How is that? I'm assuming there's no body of case law that's played out here to show how the courts would treat this. How does that play out if she's not committing a crime, but he's committing a crime soliciting it? How do you envision that playing out? What is the anticipated course of events of how that plays out?
Well, as I said, in this criminal solicitation statute, which I can give you the citation of if I had brought my notebook up with me, but this criminal solicitation statute says that even if the person being solicited is unable to be prosecuted, you can still be convicted of criminal solicitation. So there is that precedent that even though there is this immunity for a person under the age of 18, we still can aggressively punish the John and certainly the pimp for whom you've already enacted enhanced penalties.
Okay.
Ms. Apley, thank you.
Thank you very much. Did I say I was speaking on behalf of the Women's Policy Group?
You just did.
I apologize. Thank you.
Ms. Jenny Hodges would like to be heard on House Bill 582.
Thank you. This issue is very close to home for me because I've spent a lot of time as the National Director of Pro-Life Unity and the president of my foundation, Alavida, dealing with the fact that women are so devalued in our society. I think this is an excellent example of how the road to hell is paved with good intentions. And here we have the good intention of wanting civil law to show mercy, and that isn't the duty of civil law. It's to show justice. And so here in our attempt to be merciful to those children who are held hostage by pimps in the city of Atlanta, we focus on them rather than properly prosecuting those who traffic in humans. Under Code Section 16-3-26, these children are already protected. The argument that pimps hold the criminality of their actions over the heads of minors is insane. These are lawless people. They don't intimidate based on law. They're not going to get a copy of this law and realize, oh, you're no longer doing a criminal act by being a prostitute. I can't hold that over your head anymore. These are lawless, horrible people that need to be hunted down and executed. The discretionary ability for prosecution, I think, is pretty obvious. Yesterday, we heard testimony from top law enforcement agents that officers have the power to suspend the life and liberty of the individual. This doesn't sound like officers who are standing on the side of the road going, gee, should I take that girl in because I know she's a prostitute. And we even heard from legal counsel that said in the name of the community that officers have the power to suspend individual life and liberty and suspend the Constitution. I think that we have already, DFACS has immense power and authority removing children from households. I was actually intimidated at Northside Hospital when my 6th child was born. I refused the PKU test because it's inadequate. It isn't accurate if the child hasn't been on a protein diet for 7 days. The nurses informed me that DFACS would be taking my child out of my custody if I didn't have the test performed before leaving the hospital. So there's a lot that can be done to remove children from situations where it's felt abuse is happening. I think also the other difficulty that I find is exempting the criminal record. If you have a prostitute, if you have a child who's 13 and a prostitute, she's taken into custody, and we do have those proper triggers in place for getting her the right services, she still needs to have on her record that she was a prostitute at 13, because when I'm interviewing her at the age of 20 to be a nanny to my 6 children, she has experienced a high degree of reactive trauma. And we heard testimony today that that's a lifetime to recover from. And if I'm interviewing her as a nanny, I need to know. She doesn't need to be in the field of nanny as having been a prostitute at the age of 13. So I think what we have here is we need to totally scrap this idea of showing mercy by not getting these girls the help that they need. Instead, we should have a bill that properly prosecutes pimps with the death penalty and also we have those triggers in place for the services that these girls and these women need, and I don't think decriminalizing prostitution is the answer. Thank you.
Thank you very much. We've come to the end of our witness list and our discussion on House Bill 582. I want to thank the witnesses, members of the audience, and the committee members who've attended today and yesterday. We have a meeting scheduled for a week from this coming Wednesday to consider a few bills, and hopefully we'll see you then. There is lunch available for members in the office, and thank you again. We're adjourned.